Mr. Bond. I expect you to die. Hello, chat. Hi. See, I promised you. See, he's here. You can see him. See, he's alive. You got your Clyde fix. So, all right, buddy. I'm going to put you down, okay? What's wrong? You're like wigging out. I don't know why. Here you go, bub. Hey, where's your sheet? There you go. All right, guys. So, yes, the Young Thug saga continues. And to join us tonight as, oh, somebody says my pup is cute. Well, thank you, Jade. Thank you. And actually, before I get too far, if you guys are new, my name is Sean, also known as Potentially Criminal. I am a defense attorney in the Cleveland, Ohio area. And obviously, if I do criminal defense work, we're going to talk about a criminal case. And the big one right now is Young Thug. And, well, things are getting interesting. So let's talk about the saga of the contempt that was placed on one of the attorneys, Young Thug's lead attorney, Brian Steele. He was held in contempt by Judge Ural Glanville on Monday. And now we got through Tuesday, and now shit's going down. And it's getting worse, and it's getting deeper. And to talk us through this and help us get through it, we've got the esteemed and always knowledgeable Steve Gosney. Hi, Steve.
Hey, Sean. How are you?
Good. And if you guys are not familiar with Steve, Steve is, for the time being, is a public defender down in Florida, soon to be working with the prosecutor's office in the state's attorney's office in Miami.
Correct.
So he will be down there helping them with various projects, including ethics training and professional responsibility training, which never a bad thing to work on with the government.
Right. Well, this is a case in point, and somebody in your chat had said you don't need to follow this trial for 88 days to catch up with what's going on real quick in this crazy place that they're saying it's a courtroom, but I don't really believe it. I think it's some sort of la la land.
Yes. That's a shame saying boo.
Oh.
I mean, are you saying boo to Judge Glanville or to us? I'm not sure. I know you're probably saying boo to the judge, but so somebody is asking, Ghost had a question. Attorney Brian Steele was held in contempt. Yes, the judge held him in contempt. Signed an official order saying, congratulations, you're in contempt. Now, whether or not that's valid is a different issue. The judge can order a lot of things. Whether or not those orders are valid is a separate issue. Just like a police officer, he can arrest you. Whether or not he's allowed to arrest you, well, we're going to talk about that. So, what we know so far is, and we have updates, and I think we'll start off with Brian Steele, first and foremost. And I think the best way to start this off right now is a meme. Because you know what? Memes are great at what they do. And I think this meme is amazing. Hopefully you guys can read that. And it says, first of all, the judge says, I still want to know, how did you come upon this information? And can you play the role of Steele, Steve?
Okay.
The top one.
What I want to know is why I wasn't there.
Yes. And now we're going to go to the next one down. I'm going to give you 5 minutes.
I don't need 5 minutes.
And then, yes, then the reaction of hearing him asking to be heard again after removing his shoelaces and objecting again due to deprivation of counsel. And I will say, and then his reaction upon requesting to be housed with his client to continue preparing. And I think that's a very... I've talked to attorneys who heard about this. And they were talking about it in court. And I said, no, you guys don't even have the half of it right. And I explained it to them. And this was their reaction pretty much the whole way through. I just think it's fitting. It's the chairman going, well, yes.
Can we, the first thing, can we say the first thing?
Yes.
Is our lawyer who was held in contempt and said, I want to be held in the jail with my client. Do you think that guy's going to go to jail for this Friday? What's the answer to that one?
Well, there is an answer in chat. I'm kidding. I don't want to keep you guys waiting too long, but.
And can we say that Legal Mindset was on here, and did we call it? I think Sean and Gosney called it last night.
Yes.
We even got the day right. We said it's going to happen this morning.
Oh, I said by Thursday, but I don't think it would take that long. They
I
would.
said it was going to be today. I said it was going to be tomorrow morning.
Yes. But yeah, I just I thought it might take him a second, just because that's just the nature of, you'd like to say that's not how things go, but that is how stuff happens sometimes. And it's just yes, I'm glad they did it quickly. I am glad they did it quickly. The fact they didn't, if they would have taken longer, would have upset me. But yeah, and I will say, ultimately, going back to what Brian Steele did in there, I mean, it's pretty easy to call it. I mean,
This is an OG call.
it was gangster. It was a gangster call. Chris Carlos says, "What if all these accusations are false?" We'll get to.
Well, yeah, we'll talk about that because I wanted to maybe play a little what if game with you, but let's kind of go through this methodically. I know you know what you're doing. I'm in good hands in the potentially criminal stream.
And if Mindset is free, I'm going to send him another. See if he can join us. I don't know. He's busy out there doing international
Pokemon streams.
To the Pokemon streams.
Yes. Well, you're talking to the criminal guys here, so
yes. All right, chat. So let's get started with what the courts did today. So it first started off, and I learned about Georgia appellate law today, and this is really cool because I don't know if this would happen. This wouldn't happen in Ohio. And I don't know if this would happen in Florida. This is really unique. So what happened today? Well, we started off with the Georgia Court of Appeals. And they start off with this interesting thing. So they talk about that Brian Steele did file an emergency petition pursuant to the rules. He's seeking relief from the impending incarceration imposed upon him for the criminal contempt. Now, this is the part that was weird. The Georgia Supreme Court of Georgia, has determined that if a murder count in an indictment remains pending below, the jurisdiction is automatically with the Supreme Court.
Okay, well, I can comment quite a bit on this. Okay, now in Florida, jurisdiction for death penalty cases is with the Supreme Court. Okay, so if it's a capital case, original jurisdiction lies with the Supreme Court.
Yes.
Right.
And in Ohio, we have that too.
Right. So now this case, it's saying murder count in the underlying indictment. So that they may have broader jurisdiction. I don't know that. That's a Georgia court question. But obviously the appellate court is saying that original jurisdiction lies with the Supreme Court in all murder cases. So that's interesting. That's a little wrinkle that I wasn't familiar with in Georgia. That's why you want local counsel, because they know these wrinkles, right? The second question to me, though, is it's a criminal contempt proceeding, which to me is a criminal contempt proceeding is a separate criminal kind of count, an act. So the jurisdictional question is kind of interesting that the lawyer's criminal contempt count is somehow linked into his client's criminal indictment.
Yeah. Well, I think that's fair because it's surrounding the case. I mean, that makes sense to me. So the way this worked is, and yeah, they say this, and they're saying in Ohio too, if you have a death penalty case, your appeal is automatically to the Supreme Court because they just take care of it. And they're like, there's no point in having the intermediate court. They're going to just look at it. But they say here, although this appeal arises from a collateral order of contempt, it's undisputed the nature of the underlying action is a criminal prosecution. And that makes sense. So it follows that the order of contempt is a matter lying within the Supreme Court's jurisdiction. Okay. So this got transferred immediately over to the Supreme Court. Okay, so it goes.
That is, look at the date. That's today. It got transferred to the court.
Yes, today.
Right.
And the Supreme Court got it today, and they made an order. Here. All right, so they made an order, and this is today. Oh, Wrong thing here.
Wrong marker.
Yeah. Look at the date, chat. Today. This is how fast they're moving. And this is in re Brian Steele. Or in re Brian Steele. And that means in the matter of. Because he doesn't have his own case. So Brian Steele appealed this to the Court of Appeals. At the same time, there was a Court of Appeals emergency motion for supersedis bond, meaning they wanted a bond to be ordered. So the Court of Appeals transferred that. And the court actually here is saying that, and they're noting that we have the ultimate responsibility for determining whether this court has appellate jurisdiction. So even though the Court of Appeals said, hey guys, this is yours, the Supreme Court gets to say, no. We appreciate you telling us, but it's our decision whether or not it's ours. So they did end up accepting it. They did end up granting a writ of certiorari as to and it's just like the U.S. Supreme Court, certiorari, is what you need, to the emergency motion and the appeal of the contempt order.
This is amazing, Leaf. I've never.
The court is saying we're
okay.
gonna hear both things. So in the meantime, we further grant the supersedis with respect to the trial court's order holding Brian Steele in contempt. Now, what does that mean? The enforcement of the trial court's order is stayed pending resolution of the appeal. And this was today, chat. So literally,
so it got transferred today. The court accepted so the Supreme Court of Georgia accepted jurisdiction today, and they granted supersedis bond today.
Yes, and
so this
all the
happened
justices
in one day,
except for one who didn't participate because there might have been a conflict, or he may not have been around. But all the judges immediately were like, "Yep, we're taking it," and they immediately came out.
Judges, except one who's not participating.
Yeah, so, who knows why he wasn't there? But it's
this was a Zoom call. This
that.
was an emergency Zoom call.
Yes,
and we can talk about why this happened so quickly and what's behind this.
Sure,
but
if you want to.
Let's just say that clearly this trial is on their radar screen. Can we?
Oh yeah.
Can we say that? Maybe that's the first tea leaf reading.
Yes, that 100% is. This is 100%. And if you want to explain why that is, you can please feel free to explain.
Well, because this judge is single-handedly destroying any respect for the judiciary and for the court systems of Georgia. He is doing that publicly and single-handedly.
Sure. But I was going to say, Steve, and this is where I think I talked about a little bit as well, the idea of why would they respond so fast to a contempt hearing? Because contempt, they will generally respond quick regardless.
Right. Yes, and that is true. Well, the first thing is the granting of the supersedis bond and staying the order for jail is because it's like at first do no harm. And there's a question of mootness.
Yes.
So if the guy does, if he does the jail, he's in the middle of a trial. He's defending a client in the middle of a murder trial,
and the trial will be
10 weekends in a row in jail.
And if he serves that, he'll have served this long. The trial will be going long after he's done. And a normal appeal, guys, even for like a misdemeanor thing, could be like 10 months long before the court makes a ruling. So in 10 months, he's done. And that's not fair to him if it turns out, the judge was wrong. Because as you said, Steve, what do you tell Brian Steele at that point?
And this is
his hair and tell him it's okay. Well, no.
What we were talking about when I said there needs to be an emergency motion for emergency writ of some sort, and that's what it was done. And when it's something that's titled an emergency, I will say even my court here, the 5th DCA in Daytona Beach, Florida, when we do something in an emergency basis, they do look at it immediately. I mean, and we don't use it's not something that's abused. We don't people label everything an emergency so they get time. No, we're very respectful of the court, and when we do it, I've seen that the courts do respond very quickly, and they put this to the top of the pile. So good for them, good for the Georgia Supreme Court. And I don't know. I mean, we need to continue our path of all the excitement from today,
Yes.
from the Young Thug trial.
Well, and Steve, I was hoping you'd be going 1 second longer so I could finish this thing I'm doing.
Okay, well, 1 second longer is, so what you have is an emergency motion for superseded bond. Superseded bond on criminal contempt. That's basically, I want to say this until the appellate court has had a chance to review what happened here. So everything is in stasis. And they granted that, meaning we're staying it. So he's not going to jail this Friday. That's the bottom.
And that's the big thing. He's done. Right now, it's all on hold. And here's the thing: he's never going to go to jail. The Supreme Court of Georgia is going to look at this, and they're going to say, "Nope, we're not doing this. Not in a month of Sundays."
And what all this defense lawyer was doing was making a motion on behalf of his client in a respectful and professional and thought through and very aggressive but zealously advocating way, which is his role. And the judge didn't like it and was holding him in contempt for basically doing his job. That's why, and the entire defense bar is up in arms on what's going on here.
Oh yeah, and it's Jean Deatta Smith is saying the judge should have backed down when everybody showed up, and now all the lawyers in the Supreme Court are involved. I mean, here's the thing: I didn't write a book. I read a book when I was like, I don't know if you heard me say this, Steve. I didn't read comic books as a kid. I was like a 13-year-old boomer. I was reading like Tom Clancy novels and stuff like that. But I read this one book, and it was about like World War III starting. And this Russian submarine was following an American carrier, and they were practicing launching the missiles. Because that's what you do. You drill and drill and drill, and they practice. Well, in the middle of their practice run, they accidentally launched one. And immediately the captain's like, well, send the rest because it's too late now. And I think for Judge Glanville, there's a little bit of, I'm already like, I think he kind of understands. I think he understands, like, I'm already here. But I will say one thing. And there's an attorney I follow who's a Georgia practitioner who says that he kind of he found another guy who was making an explanation why this might actually make sense. Or like, at least here's a good faith interpretation of what the judge is thinking. It won't, like, he'll still lose, but he might be able to escape getting his like PP slapped. Too bad. Like, they wouldn't disbar him, but there's gonna be, and I'm trying to see where this guy's thinking.
At this point, I'm wondering whether or not the judge himself may be facing criminal sanctions.
Oh, well, we're gonna get to that issue because there's we'll
talk about, we're gonna get that because there's some more stuff here, but we got to talk about the truth of these allegations, which is suspect. But
so let's move on. So these happen. In the meantime, the actual motion for recusal was filed by one of the other attorneys. And the attorney for Yak Gotti, which is one of the rappers, that's not his real name, that's his rapper name. And he's on Twitter too. His name's Doug Weinstein. Filed it. And he filed the recusal motion, and we got up in front of the judge and they talked about it. And oh my God, this is ridiculous what happened.
Well, can I set this up a little bit? Because I think you're going to play the video of him arguing it. All right. So the setup here is, so here's the way, and this is the way Florida works. And from reading and understanding the statute, it looks like Georgia is the same. And that is your first disqualification motion against a judge, the first one. All you need to do is file a disqualification motion within a very short time frame, but in a timely fashion, within the event that makes you suspect you're not going to get a fair trial from that judge, right? That's number one. It has to be timely. And number two is it has to allege facts that, if true, would cause a reasonable person to believe that they would not get a fair trial. The judge himself cannot pass on the underlying facts of what is alleged. If it is sworn to and it alleges facts that, if believed, would place that judge in a position of being suspect, right, of being not fair, the judge can't say, well, that's not what happened. That's not true. He has to say, If this is taken as true, I have to grant the recusal.
I think there's some issue. I don't know. I'll defer to you on that. But I just know that there's a big discussion about this. And in the meantime, there was another ex parte bench conference because the guy, Little Woody, was still testifying today. He was still on direct. And we haven't gotten to the defense yet. Because once again, if I'm on the defense, I'm going to say, what y'all talk about? And I would dare the judge, and the judge would probably, there'd be an objection sustained. I'm like, did the judge ask you to lie?
This
Objection.
trial has to be stopped.
And we're going to get to the hearing, guys. We're going to get to the arguments. And then we're going to get to the motion, because the motion. You guys are saying Danny On and Runkle. I didn't see them in here. If they're here, tell them to wave. I'll shoot them a link if they're interested. But this is what happened this afternoon. So this. Now we got good audio today, chat. So here we go.
Weinstein, you filed.
Here we go. They took a recess and they came back.
My attention, Mr. Weinstein, you filed a motion to recuse me. You filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit. Baptiste versus the state, I invite you to take a look at that. And that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying.
Now, on his face, he's correct. I can't ask for a judge to be recused because he made a ruling I didn't like. So if he ruled against me, so
that's the way he is perceiving what's going on.
But he's stating a correct. His statement of law.
That is true. But that would be assuming that the motion itself said you ruled against me, and therefore I don't think I'm going to get a fair trial. Therefore, you should be recused.
And I've seen that happen before, because sometimes you have to deal with your clients. But yes, he'll say, because I ruled against you does not. And if this was a normal situation, he'd be correct. But this is not a normal situation. And the discussion of why this is a normal gets very heated very quickly.
But nor is that what the motion alleged.
Yes. Well, we're going to go through. Yeah, the motion is very, very different.
You don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right. I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial.
Yeah, I would argue meeting with parties outside of court is extrajudicial.
Well, and the affidavit
yes.
The affidavit actually says that he is weighing in.
Well, the affidavit alleges felony conduct.
Yes, on the part of the judge, pressuring witnesses to testify against defendants.
Yes.
That is enough to make you, if believed, enough to make you believe that you won't get a fair shake from the judge.
And Steve, I don't want to spoil it, because I want to see them to read it. But yes, just listen to this next little bit, chat. And listen to this attorney, because all these guys, all these attorneys, this attorney, Brian Steele, these guys are headhunters. They are not backing down. They want to fight. It's impressive, but they're fighting in the proper way.
And I don't, you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse. I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And then you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion. Okay.
Would you grant a certificate of immediate review?
No, sir.
Because
No, sir.
if you grant that certificate, you're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case. Okay.
I don't agree.
And I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But
Okay.
aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you grant.
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court.
That's hilarious. And here's the thing, chat. He just stood there and said, when you file a motion to recuse and the judge is threatening you, that means there's now grounds for the motion to recuse. If Glanville's claiming there wasn't now, there certainly is now.
The judge needs to off this case immediately.
Yes, he has lost his damn mind.
He's lost his mind. I wonder if there might be some kind of mental or physical problem with the judge right now.
Yeah.
I mean, has he had a stroke or something?
I don't know.
Is this the way he's always been?
I don't know. I will say, one of my guys, J-Rock, he practices down there. He says he's never like this. Like, he says he's talked to his colleagues and they think he's just lost his mind. They think this trial.
He has lost his mind. This is an emergency situation. It's like they need to act. They almost need to do an emergency removal of him off the bench.
And 10K, you're saying you missed the threat. We'll replay. We will in a second. Andrew is asking a great question. Can you appeal the denial of certificate?
They don't need to issue the certificate. He can do an emergency motion.
Yes, an emergency motion, can be filed, but the Court of Appeals is going to look at those really hard because, you're saying an emergency motion, the Court of Appeals are going to be like, well, what's the big deal? Now, in this situation, they're going to look at it and go, oh, but if you filed an emergency motion for an interlocutory appeal and it's on a procedural issue and the court hadn't granted you leave to go file it, they're going to be like, yeah, we're rejecting this. Go back to trial. So in this situation, yes. And if you really you can always file something. He can't stop you. It's just that certificate and all of that generally pauses everything. And the court's also acknowledging, there's an issue. I don't know what the right answer is here either. I've made a ruling, but go appeal it. This is not one of those times. The judge is just being a lunatic. And we'll get to that threat. And the guys,
and the problem is that it's an imminent threat to every defense attorney in that courtroom, as well as their clients.
Yes,
and that's why it's so egregious and so bad. I've never seen anything. Well, I've seen something quite bad, but this is absurd.
He's going for the high score.
He needs to be disbarred immediately. I don't know how else I can say it. This is such a horrible.
He needs to be immediately immobilized, and then we could figure out later.
We can figure out what's wrong, but he needs first do no harm. Everything he is doing here is harming. It's harming the people of Georgia because these are people who are on trial for murder.
Harming the United States.
The United States. I can't even get over how bad this is.
Yeah. And you guys, when you're hearing those threats, if you're not a lawyer, these don't sound like threats. But when when you hear these words coming out of a judge's mouth a lot of times, it's them warning you you're about to step on something and you better be careful.
Responsibility. Remember, we have.
So
Now, Your Honor, if you bring.
Sir, I'd be real careful about what you're pleading at this point in time. What
You're
you're stating to
threatening
the
him with
court.
contempt.
Like, just as a matter of professional responsibility.
well, I think he's threatening him with that, but he's also threatening to grieve him and report him that
Right.
I think that this affidavit, I think he's trying to make a claim you're lying. You have a duty of candor to the court. You have an overall duty under Rule 8.4. You have duties, and he's threatening him with like you're stepping into an ethical minefield. And the funny part is he's the one who laid it out and he's running around in it himself. So that's what he's threatening. He's threatening him. And I've been in courts before where the judge has said, like, Mr. So-and-so, you are walking into a very murky area with the professional rules. And that's their way of saying, like, I don't think this is a good idea. You should probably stop. And usually they're saying it and it's warranted, but this guy is trying to bully the attorney.
Well, and I expect that also, just sort of a little inside baseball, you have a team of a whole stack of attorneys here, and they are tagging up on which attorney brings which motion at what time.
I think so. Oh yeah, this is all coordinated.
Yeah, so it's coordinated. So they're dividing up the workload, and they're saying, okay, this guy, I haven't seen him before, but he's up on this judge recusal motion, and so he's going to occupy the judge.
And every day it might be a new, each one of the attorneys for the next couple of days brings up the recusal motion, brings up this, brings up that. And that way you're not, it makes him look even more insane because then he's threatening everyone.
Right.
And it's also just not fair. Like, I'm sure Brian and Steele's just like, fuck, I don't need to keep standing up and getting yelled at. Like everybody else wants to be involved. So. And Trenton is saying Weinstein's been quiet. He pushed his chips in. They're all going to push their chips in. Glanville called and they're like, here, no rakebacks. The lawyers put their rings together, kind of. In a case like this, you will. This type of case, you're going to put your rings together because if they all go, they're all probably going to go down. They're all going to walk or they're all going down. These types of cases, especially these guys are like, these are the bigger entities in the organization. So, but let's listen to the rest of it because there's more threats. We're going to skip back about 2 seconds.
At this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time I've denied the motion. Okay.
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
And then they brought back Lil Woody.
I'm trying to think. Somebody asked, how is it, what is the appellate courts have jurisdiction over him? So the JQC, the bar has it.
I think the Judicial Qualifications Commission could suspend him if they thought his character and fitness was an issue. And I think his fitness is an issue right now.
If fitness is an issue, it's appropriate for the Georgia bar could do an emergency order suspending his license. It's sort of
I don't know if they'll do that. That's
they
probably
could. I'm just waiting out the possibility because it's like if you're stealing from your trust account and they find out, they issue an immediate suspension. This behavior is such that I think an immediate type suspension would be warranted, and that would immediately remove him from the case. I also think there may be, theoretically, you could have a criminal complaint against this judge for the tampering that he did.
Well, we're going to get to that.
And that may be federal.
Yes. Well, If you guys
If
want to,
we
if you
had,
guys,
but the problem is, look at who the prosecutor is and look who the
Yes.
feds are.
well, yeah, that becomes an issue. And if you guys wanted to see a RICO, well, here's a conspiracy. So this is a conspiracy, chat. And if you look, it's dated today at 3:02, and it was a motion filed to recuse Chief Judge Ural Glanville. So DeMonte Kendrick, who is Yak Gotti by his street name, files this motion. And this is just a little bit of case law they throw in just about what's going on. And Steve, if you didn't know, it's a 65 count RICO indictment against 28 individuals. Just think about, would you ever want to prosecute an albatross like that?
It's unwieldy.
Yes.
You know, federal courts do this. It reminds me a little bit of a federal type
Yes.
case, but federal courts are much different, and I'm not as familiar with them.
Well, federal courts,
they're good at complex things.
well, yes, and they actually, well, the U.S. attorney, the DOJ is still kind of sketch, but they're not just the Bumpkinville prosecutors in Georgia doing this.
and
Which is what Fannie is. But yes.
There's a lot of tools, coercive tools the feds have that the state doesn't. I would say this requires an extremely sophisticated and well-functioning prosecutor's office, as well as an excellent judge. And I don't think that we have either one of those things.
And the sad thing is, this is one of these times where the defense side of it is exemplary.
Every defense attorney I've seen here has been great.
Going through the trial over the past couple of months, they have been phenomenal. But here's the thing. Jury selection began in January 2023. The jury trial began in November of 2023. The state has presented less than half of its current witness list, which the state announced it could be increasing based on circumstances, and this trial is going to last well into 2025. And right now, there are 6 defendants presently on trial. They've been denied bond and have been incarcerated for over 2 years. I thought it was 18 months, but 2 years these guys have been sitting. 2 years they've been sitting there.
That's not unusual. Like death cases. Rosemary Peoples, who used to be our lead capital, now she's with the Jose Baez firm, does capital trials for us.
And I get that.
And she says when she has a death case, she says that she tells them we're 2 years out from a jury trial.
Sure. But this case, though, this has been such a dumpster fire. There's been almost a whole year of just dragging around and screwing around by the state and the court. Like, this is all like it. This is, I would argue it's almost a punishment for them at this point. So anyway, we talk about Kenneth Copeland. He testified. Okay. Now, despite being warned, he refused to testify. And then the judge was incarcerated. And everybody was told we'll start Monday at 8:30 a.m. Have you read this yet, Steve?
I skimmed a little part of it, so I'm still working.
Chat,
so I'm
here
listening.
we go. This is the most obscene thing I've ever heard of. So on Monday, June 10th, defense counsel were present in the courtroom at 8:30 in the morning. They got to the courthouse. They were admitted entrance in the courtroom 1C and seated by 9 a.m. Defense counsel waited and waited. Between 11 a.m. and 11:30, they sat there for 2.5 hours, chat, by themselves. By themselves in a courtroom. The chief judge took the bench and announced that Copeland was prepared to testify. Now, here's the thing. Remember, it's just them. There are no prosecutors. It's the prosecutor sitting with the judge, according to the allegations made. There's no court reporter. Why? Because the court reporter's hanging out with the judge. There's nobody in the courtroom but them and their clients, just sitting there waiting. Nobody knows what's going on. I'm sure they asked one of the court staff, where the hell is everybody? And they said, we don't know. Now, maybe they were sworn to secrecy or they weren't told. But these guys sat and waited. And then this part here is very damning for Judge Glanville. Brian Steele inquired to the court as to the delay and what occurred prior, and his inquiry was not accepted. So Brian Steele said, "Hey, Judge, what's the deal?" And the judge said, "None of your business." So, unknown to any member at the time, the judge, with ADA Love, ADA Hilton, the other assistant district attorney, the district attorney who always gets up and has been making noise. She's the black lady with short hair. That's ADA Love. The other members of the DA's office, deputy.
Who is Hilton?
She's the other assistant district attorney that's
Okay.
on there. That's not the guy. It's the two.
I noticed that the guy is saying nothing and looks down all the time.
Yeah,
I wonder what his
he's like,
role is.
I don't think he wanted any part of this shit, but he
I
shouldn't
wouldn't.
be
I mean,
reporting
this,
it. Yeah, but that's when you know this is going down. You have duties to report and disclose.
and I would expect, and I'm just guessing,
Mhm.
that the attorney for Mr. Copeland
Yeah.
emailed defense counsel.
I think so too at this point. I think that's clearly what happened.
As she has a responsibility to do under the rules, and that meeting is not confidential, so it's not a problem
Mhm.
for her to do that.
Yes.
It would
Yep.
be her duty to do that.
Yes. So here
No,
we go.
this is new. Didn't Gosney go over this good logic? This was filed today.
This came out today, guys.
So this is the allegations. This is supporting the disqualification
Yes.
motion, right?
Yes. This. Now we're learning exactly what happened, and this is pled with such particularity in detail. It's guys, when you're gonna look at this, you're gonna say it's just like when you watch an attorney asking questions that are very detail specific. Why is an attorney asking it that way? Because he knows the answer already and he knows it's true.
I wonder also, we're talking about
Yeah.
people that could come in here. I wonder if the governor himself could also come in and suspend. Maybe I know that they could do that for the state attorney's office, and
Mhm.
maybe that would be appropriate here.
Well, I think that's a separation of powers issue, though, because
No,
with the
because it's
with the
executive.
state attorney, though, that's the executive branch. He can, cleave heads left and right. The
Yes,
judge
the governor.
suspending it.
What I'm saying is the governor of Georgia could basically come in and disqualify the Fanny, whatever her
Oh,
name is.
yes. I think there's got to be something, especially given how. Although I didn't realize this. Georgia's constitution still has a lot of reconstruction running through its veins. There's a lot of weird quirks in it.
Well,
how
and I'm
things
not a
happen.
Georgia lawyer, but I know that
Yeah.
Governor DeSantis in Florida
Mhm.
has done that to two different state
Yes.
attorneys in Florida.
Yes.
One was pretty clean. The other one was a little iffy.
Yes. Yes. So here we go. And now we talk about this. And this is the motion, not the actual affidavit. No member of defense counsel was present, despite it being a subject matter of a critical phase of the trial. Upon information and belief, neither Judge Glanville or any member of court staff, nor the DA's office, made any member of defense counsel aware of the ex parte meeting before the meeting was held, during the meeting, or after the ex parte meeting. Now, this is where they kind of tell you who told them. Because they're saying, upon information and belief, nobody listed here, the judge, his court staff, the DA's office, told us what happened. So
but
that
it does
only leaves.
leave the court reporter bailiff.
Well, I think she counts as court staff, though. I think that lumps her in court staff. That also includes court security, I think. That's vague. You're right, though. It's vague enough to give some smokescreen here, but it does leave you with either Kenneth Copeland, which would be impossible, unless word got out other ways. I don't know, or the attorney that was there for Copeland. And I think they're kind of doing this. So anyway, Copeland testified briefly, and that's where he was making fun of the prosecutor and going pretending like he was like a 10-year-old, which I thought was kind of funny. One or more members of the defense counsel were made aware of the meeting, and upon information and belief, this is what they believe happened. So Copeland announced he would invoke his Fifth Amendment right and not testify at this meeting. Oh, hold on.
This is the recitation of what supposedly happened behind closed doors between these parties, excluding the defense. So that these bullet points, these little dots, this is what they are saying was said behind. Which I will say, after I did read through these bullet points, this is worse, much worse than what even I was expecting. What they're alleging now, I will say that the source here, we can't. On the one hand, we can't say this is fact.
Yeah.
But for
Yes,
the
we'll get to
judge,
the
the
affidavit,
judge
which
has
are
to
the
take it as fact
yes.
for the purposes of recusal.
And we'll get to the recusal part. So upon information and belief, Copeland stated he would sit in jail for 2 years rather than testify. Now, Glanville informed Copeland that he could keep him incarcerated until additional defendants were tried, not just the 6 currently on trial. And I don't think that's legal. I don't think he can do that.
But he's also making threats behind
Yes, he's
closed
threatening him.
doors.
Yes. That he's threatening this witness and he's inducing him to provide testimony by lying.
But it's just he's prejudging.
Yes.
I mean, it's insane. He's basically putting his thumb saying, I want you to testify in a certain way, or I'm going to do something. You are threatening the witness. Now the defense needs to know that.
Yes,
so that they can cross-examine. Isn't it true that you were?
Yes, it's an entirely an issue there. This is guys, this is stuff the Supreme Court has already said. This is not how that works.
Well, and the Supreme Court said that there's a case called Giglio.
Well,
but that is prosecutors doing this. I have never, ever even heard
of a judge making a Giglio problem. Yeah. Yeah, well, here's though where the prosecution gets involved. They pipe up and say there were over 12 defendants left. So I would argue they're backing up the judge saying like, well, yeah, we've got like 12 people left, buddy. It's going to take forever.
They're tag teaming him.
Yes. And then based on these coercive actions, they're saying he would testify. Upon information and belief, the judge provided him with a printout of the perjury statute, the false statement statute of the state of Georgia during the meeting.
Again.
So now he's citing the law to him and threatening him with, but the judge is saying, how does the judge know he's lying? He just says, I'm not going to talk. Well, that's not now he's intimidating this witness and tampering with it, but now he's threatening him with perjury. The guy said he's not going to lie. At least here. Like, why, but we'll get to this. But this is more threatening and tampering by the judge. But we get to the next part where Copeland said to Hilton, if called, he'll simply lie. Now, that is a Giglio issue. Did you tell the prosecutors you were going to lie and say whatever you want? Yes. They are entitled under the law. Steve, can you take over for 1 second? I have to take this call real quick.
Sure. Yes. So Giglio or Giglio or Giulio or however you want to pronounce it, Mr. Chat, basically it's a federal case wherein the state induced a witness. They basically placed on the witness stand a witness that they knew was going to lie. So they knowingly placed false testimony in front of the jury. That's called a Giglio violation. Giglio, I call it Giglio, but whatever. Anyways, that is a massive. It's beyond Brady. Everybody talks about Brady compliance. Brady is obviously implicated here because the state has a duty to turn over exculpatory evidence, potentially impeachment. There's a whole bundle of things that the state needs to disclose under Brady, and all of these things would be included in that. Okay, that's sort of the threshold thing, and we have a lot of Brady problems generally in criminal courts, and it's one of those things that state attorneys really need to be on top of their Brady requirements. For example, cops, police officers who have lied under oath or under investigation in other proceedings, the state has an affirmative duty to inform the defense counsel of other times in which their veracity for untruthfulness has been presented in a court or in, say, a police investigation. Okay, so that's Brady. Giglio, which I'll say Giglio in my words, like gigolo, it's just a gigolo. Yes, you can have both. Giglio means the prosecutor knowingly puts on false testimony, which is so far above board. It's so far beyond what should be done. A prosecutor should be the advocate for the truth above all else, right? And so that the truth is the fundamental thing. If a prosecutor is knowingly presenting perjured testimony to the thing, that is a Giglio violation and is really, it's the worst thing that I've ever, you see as a defense attorney. It's what you fear. And this is what's going on here. So they're saying, well, if you read between the lines here, I'm going to lie on the stand, and the state calls him anyway to say what they want him to say, regardless of the truth. That's knowingly, suborning perjury from a prosecutorial standpoint. It's a disaster for the court system. And people have heard me rant and rave about truth and how lies have permeated our society and our system. And this is what you have here, is lies being taken and put into our judicial system where people's liberties are at stake. And I'm no fan of these defendants. I don't really know them. I mean, they look like a bunch of thugs. I don't know. There could be criminals. They could be running the game. But here is the system itself self-destructing by swallowing lies and untruths and spitting them back into the system. For what end? It's a self-emulation.
Mm-hmm. Well, thank you for that. And I apologize, guys. I had a call come in. I had to take that. Little important for me. So
he's a working lawyer.
Well, yeah, this was a bit of a
no problem.
Anyways, yes, how it goes in life.
I was just explaining the difference between Brady, which is a disclosure thing, and Giglio, which is a prosecutor knowingly putting on perjured testimony. Well, but here it's even worse, because now you have a judge who is complicit in putting perjured testimony on the thing, cooperating with the prosecutor to knowingly put on false testimony in front of a jury.
Yes.
I've never heard of that.
Mm-hmm. And what I was going to show real quick, just so people understand how serious this stuff is, and I'm going to do this because I've minimized all of the stuff on here. This is an example of a discovery request I do in a case, and this is for one of my clients. So, it's the defendant's written request for discovery, and I got a bunch of stuff I asked for, but when you get down to here, and what I ask for is all kinds of stuff. And the dog's barking among all kinds of stuff. And you ask for, the names of any witness that might establish the innocence or mitigate the punishment of my client. But then we get down to here. All evidence favorable to the defendant and the material to the guilt or punishment of the defendant discoverable under Brady v. Maryland. But you also have United States v. Bagley and Kyles v. Whitley. Those are Brady and its progeny, the ones that came from it. And then down below, this is where you ask for any contents of any promises, grants of immunity, guarantees, assurances, proffers, or agreements of leniency of any kind, oral or written, entered into by the state of Ohio, the prosecutors, or law enforcement with any co-defendant or witness in exchange for their testimony or statements. And that's
that's right out of Giglio.
Yeah.
And there it is. Like, look.
Yeah.
And this is what we have. Grants of immunity. We're talking behind closed doors with the judge, excluding the defense. And they said that this was not communicated to us.
Yes.
A grant of immunity, agreements for leniency, and in exchange for testimony statements used against the tenant. And that is squarely under Giglio.
Yes. But that's where, and you don't have to do this as an attorney, guys. No, not all attorneys do
automatic.
This. Well, yeah, some of them, I want all discovery entitled under Rule 16 of the Ohio Rules of Criminal Procedure, and that should cover it. But you know what is easier? And you get the attorney, this way I'm saying, listen, knuckleheads, I want it all. And I'm being explicit. But I'm saying in addition to everything else, because then I get down to the bottom and it goes on for a little while, and I say any other discoverable material that I would be entitled to.
This is a standard sort of, we call this boilerplate defense motions.
Yeah. But this stuff here, I think, is always important. You always ask for the Giglio material.
And then
You
also
just
what you can do is pre-trial, you
Mhm.
get rulings on all of this. And generally, good prosecutors will agree to all of this stuff. They
Yes.
will say, Your Honor, we stipulate to a granting of you that we grant the defense motion on all
Yes.
paragraphs because you're not asking for anything that is not already required to be disclosed. And an ethical prosecutor, and they might point a quibble or two about
Yes.
a paragraph or two if there's something that they want to talk about.
Yeah.
But a good prosecutor will say, yes, we agree that's our obligation. And we would, and then the judge will say, okay, based on agreement with the state, we grant the
Yes.
defense motion and it's done with. But
Yeah.
now you've preserved it, right?
Mhm.
You have an order from the court that's directly appealable
Yes.
if it comes up later.
Mhm.
Although Brady and Giglio should be
They're
self-enforcing.
self-enforcing, yes.
Right.
And that's what I think is true. Oh, hold on here. What is
Now, recognize that a boilerplate motion without an order is nothing.
Yes.
So you need to
Yes.
get it ruled on. This is lawyer tips.
Yes.
Any of you lawyers in the chat, because and in pro se people make that mistake all the
Well,
time.
this is just a request. It's not a motion yet, but if I get everything, and it depends on the type of case, because I use this for all my cases. But if I know there's a case where there's like a snitch involved, things like that, I have, and one of my mentors mentioned that to me. You get a motion for your discovery, and here in Ohio, that gets you a weird look because Ohio does open file discovery. But it's just the idea you protect your client because now it's on the record that they've given everything and they're agreeing to give everything. But this is where it keeps going, guys. Copeland, his statement he would lie. The one assistant district attorney said she wouldn't prosecute him if he were to lie on the stand.
Okay, can we step back for a second too
Yeah,
and talk
yeah.
about how this should go?
Yes. How this
Okay,
should go, yes.
the way a state attorney generally should do this. All right, and this is typical. The grants of immunity to overcome Fifth Amendment privileges. This is the way it should work. All right, you got a witness. He's a key witness, and he's on the defense side. He's hostile, but he's squirrely. You know he's hostile.
Yes.
So what you do is you do what they call a proffer. So the person makes an under oath statement, given a grant of immunity, and say this is what he will say within a proffer. Okay, and then so now you know what he's going to say.
Yes,
and then you grant the immunity over that proffer.
Yes.
So then what happens when he gets up there and he changes his story? You can get him for perjury.
Yes, and with the proffer, you guys, you don't do the proffer right there. You wouldn't want to do it in court. You'll go to this person ahead of time and say, look, we will offer you immunity for your testimony. You're going to sit down with a detective. He's going to sit there and you could do it under oath, or he can give a proffer where you sit there in an interview room and the detective has a bunch of questions he's going to ask, and he can do a proffer that way. And that
usually that's negotiated through defense counsel, like
and
Sean.
I've done proffers, yes.
Where if you say, this is what my client's going to say, and then the prosecutor says, if that's what he's going to say, we'll offer you immunity. Then he comes in, does the proffer, you do it, it's under oath, you have it, they offer the immunity. Now here, if they don't do the proffer, that guy that you call, you could give immunity and force somebody to testify, but you are stuck with whatever answer they give on the stand.
And that's the thing. So, for example, in the case I have where I got a guy who's got a aggravated murder case, we did a proffer. We didn't do it under oath, but we sat with the detective, and the detective had a bunch of questions. Now, my guy had already talked on his own prior to dealing with me, which he wasn't supposed to do, but c'est la vie. But his testimony, his story was consistent. It's been consistent for months and months on end. And that was part of the thing, was just showing. And then the prosecutor or the detective had a couple of questions that my guy was able to answer. And we also were able to provide more information because now I'm there, I could volunteer something like, did you know about this, detective? And he's like, what about that? And, his ears perked up because we knew something he didn't know. And it's a question he wanted to know the answer to. And I said, you can inquire. And my guy provided the answer. And that actually helped a lot because they were able to piece together parts of a story. It wasn't the big story, but it was like the little
Right.
pieces that they need for the rest.
To help your client out in sentencing.
Yes.
Now, but let's think about this. This is important because let's think about these two alternatives the prosecutor has. They can get the proffer, know what he's going to say, have it written down, have it enforceable, and if the guy changes his mind on the stand, do away with the agreement.
Yes,
and
the immunity's
prosecute for
gone.
perjury, right?
Yes.
So those are two things. The second thing, or give the guy, not know what he's going to say, give the guy immunity, swore to tell the truth, and just trust he's going to tell the truth.
And that's
stuck with
cowboy
whatever
mode.
answer he gives on the stand. Those are the two options.
Yes.
It is not an option to say, we will, this is the problem. We will give you immunity if you say what we want. And if you don't say what we want, we will punish you.
Yes.
That's called manipulating the evidence.
Well, that's witness tampering.
Witness tampering.
Yes.
That's
hold on one
creating
second.
a case. That's in asking somebody to lie for you, which is a Giglio violation. Oh, I'm sorry. Did I talk over you? I didn't mean to offend the host. I'm sorry. I know I talk over people. I get it. I can't help it. It's part of it is because my overheads, I don't wear earphones and it's overheads. So, but I hope Sean's not mad at me. Another call. Did he say another call? Thank you, 10K.
That was 2.0. That was 2.0.
Okay, I'm sorry. I do too. I tend to talk over.
You can't be offended. Yeah, I can't be. I don't know what you said, so.
I don't want to offend my gentle host. I have the highest regards. If you're in Ohio and you need a criminal defense lawyer, I'd hire this guy right here.
Please hire me. I would enjoy the business. I'd like, part of why I do this is I hope at some point it would generate, business at some point too. It's fun, but I'm hoping that it can be fun in a more lucrative way as well. All right, guys. So yes, there are two ways you could do immunity. You could do immunity like a professional, or you could do immunity like a cowboy. And it sounds like the prosecutors went the cowboy route and they didn't prepare. And you could prepare this in advance, months in advance. You could do this like a deposition where it's sworn. And the moment he goes off the rails, you've got a transcript or you've got a video. You said something different, didn't you? Bam, bam, bam. And you hit him. But they didn't do that. So instead, we get this crap where the prosecutor says she wouldn't prosecute him if he lies. Now, that's not illegal. There's discretion within a prosecutor to charge an offense.
And they can make that promise.
Yes.
We're going to call you anyway, and we're not going to prosecute you. Now, that needs to be disclosed.
Yes.
To the defense under Brady. But they could say, we're going to put you on, we're going to grant you immunity, and we're not going to prosecute you regardless of what you say.
And that is a promise that's binding. If the
fact
she said that now,
it's a contract.
The fact she said that, just like with Bill Cosby, we promise not to prosecute. There are no take backsies now. Because if that's how she said it, and it's not in writing, that's going to be construed against her. So he can go out and start spewing crap, and there's nothing they can do to him.
Right. He could say, yes, I killed them. I killed the clerk.
Well, and that's actually one of the things is going to be there. So Copeland also stated to the DA that he killed Donovan Thomas, and the murder of Donovan Thomas is one of the bigger things that this entire RICO case is built on. That's like the foundational murder. That's the foundational thing here. So he's going to say, I did it. Well, now he's already admitted he's lying, or he will lie, or he could lie. He's not reliable. And then upon information and belief, ADA Hilton said that that she would prosecute him for perjury if he testified he killed Thomas. But she already just said up here, I won't prosecute you.
Right. See, so now she's coercing, she is getting into the substance of the testimony and picking and choosing what she will punish and what she will reward.
And now she does have discretion, but she's already made agreements, and now she's trying to whittle back that agreement is a problem for her. And this also, I would argue,
this to me is the Giglio violation, and it's also subject to Brady, immediate Brady disclosure. The fact that defense wasn't here is ridiculous, and the fact that it's in chambers with a judge is ridiculous. There's
Yes.
just so many
Well,
things wrong with what's going on here.
honestly, though, Steve, I think this right here, technically, that's suborning perjury. Ultimately, that she won't prosecute him if he were to lie. I would argue that's almost suborning perjury at that point.
It's hard. It's hard. You know, this is.
Yeah.
We need a transcript. It needs to be recorded.
Mm-hmm. So, we're going to keep moving here, Chattel. We're going to keep moving here. So, the judge must cease to act and make immediate determination. Okay. So, when the judge is presented with a recusal motion, he must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is sufficient legally, and whether the affidavit sets forth facts if proved would warrant the judge's recusal from the case. And there's a Georgia case that covers this. But
And that's
it's also
Georgia Supreme Court 2018.
Yes, but it's also covered in the Georgia rules of criminal procedure, or the Georgia rules of superintendents of courts. Now, the rules of court superintendents are rules that a Supreme Court will put together that don't just cover civil cases, don't cover juvenile cases, don't cover criminal cases, or probate cases, or traffic cases. This is how all courts will operate. These are rules for everyone. And this rule covers the duty of the trial judge. And this is talking about the motion to recuse. This is where they pulled it from. And yes, he shall temporarily cease. He shall determine the timeliness of the motion, the legal sufficiency, and make a determination, assuming the facts alleged in it to be true, whether recusal is warranted. If it's found that
the facts true,
yes,
whether recusal, it's you have to assume. This is sort of like a summary judgment motion in civil.
Yes.
Or a motion for JOA at the end of all evidence, judgment of acquittal. You assume that the facts as presented are true.
Yes. If some or all the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. The allegations of the motion shall stand denied automatically. The trial judge shall not otherwise oppose the motion. In reviewing a motion to recuse, the judge shall be guided by Canon 3E of the Georgia Code of Judicial Conduct. And I didn't bring that up. Code of Judicial Conduct. Now they call them canons, and it's just it's parts of the canons are where they what I said 3E. Okay, so okay, hold on here, guys. So Canon 3 of the Georgia Rules of Judicial Conduct here. So the judge shall perform the duties of his office, and notice what they say. And a lot of this stuff makes sense. You don't have to be a lawyer to understand this. The judge shall perform all of his duties impartially, competently, and diligently. Cool.
Is it 3.5, was it?
Oh, hold on here. What do they say? Canon 3E, 3 echo. So Canon 3.
3.1 echo?
Yeah. What's that?
3.5 echo, I think it was, right?
Well, hold on here. No, he says down here, Canon E3, 3E.
Okay,
3 echo. Yeah.
Hmm.
So let's look for Canon 3E.
It's not properly cited.
Yeah, I don't. Hold on here. Here we go. Disqualification and recusal. Judges shall disqualify themselves in any proceeding which their impartiality might reasonably be questioned.
Okay, so let's stop there for a second.
Yeah.
The operative words here: judges shall. Shall is not a may. Is may and shall.
Must.
Shall is must. In which their partially might reasonably be questioned.
Yes.
So you must disqualify if their impartiality must or might be reasonably questioned, and they must take the facts as alleged as true.
Yes, a reasonable, prudent person. Looking at that, would a reasonable person say this seems? If you let a regular person watch any of those clips, would they say this seems sketchy? And if that's true, you shall disqualify yourself. The appearance of impropriety is toxic enough. So let's get back to the motion itself, though.
Did you look at what David just said? Is that true?
Let me see. David, are you in here? I didn't see it.
David says there have been 2 lawyers arrested, 1 bailiff arrested,
yes.
1 juror.
So So this case has had a lot of issues with jury selection. So like one of the jurors didn't show up and went like on a vacation. And there were some issues and he put the juror in jail for like a day. He made one of the jurors at one point write like a 15 or not like a 15 page, but he made him write like a little paper on the importance of like jury duty and judicial. But that's, I think the judge is trying to like, he's been dealing with some asshole jurors. And I think there are times where that's a creative way to impose contempt if you violated the rules. Like there are some times you have to do stuff and merely just fining people doesn't really always accomplish that task. One of the attorneys, there was an issue where he made one of the attorneys like buy lunch for all the other attorneys because they had done something. And that attorney was a smartass and got like a catering from a strip club. So, but yes, ADA Hilton is pond scum as well. Based on the allegations here. But yes, this has been ongoing, Steve. There is some all kinds of these people, I think, really tax the judge because some of the conduct is really objectionable. What some of these people were doing. So I think the judge actually was doing okay back then. And the defense attorney was held in contempt for, I forget what he did, but he did screw up pretty bad. So the judge said, well, he's like, can I pay a fine? Judge's like, no, I'm not going to fine. You're not paying a fine. You're going to write me a scholarly paper on, I forget the topic exactly, but he said, you're going to write it like you were trying to send it to a law review. He said, like, I'm not expecting you to like break new ground, but the judge was imposing a punishment because merely just saying, pay me money. Well, if the guy's got money, that's not a threat. So a defense attorney had to write a paper as well. Yeah, he was late to court, I think, but he had been doing it a lot, or there was a big problem. And yeah, the attorney actually offered. You're right. It was like $1,000, and the judge said, "I'm not letting you do that." So, like I said, there are times where the court has the ability to. It was about the importance of professionalism, which is hilarious in hindsight. One of the attorneys got caught smuggling drugs to one of the defendants. There was a drug deal in court itself between the defendants. Like there's all kinds of crazy shit that's gone on in this, Steve. So let's keep going though. Let's keep going. So they talk about it. The present motion for recusal is being timely submitted. Motions to recuse along with the accompanying affidavits are required to be submitted not later than 5 days after they learn of the alleged grounds of disqualification. And that's important. You can't just go a month later and say, hey, judge, we heard about, we thought about it. Now we want to get rid of you. You have to act immediately. So that is the big thing here. It's timely. Given the most recent incident occurred on June 10th, a 2-day period is timely. The present motion includes a sufficient affidavit, and it's done by the attorney. He has an affidavit. In a review, it clearly states the reasons for belief that bias and prejudice exist. The affidavit specific to time, place, and persons. The recusal is based on the facts. Yes, and the holding of the improper ex parte hearing, which violated the constitutional rights of his client, including due process and a fair trial. And this is where they talk about the Uniform Superior Court rules. So this is the court rules for that court, which prohibit ex parte communications. And they are also talking, the ex parte violates the Georgia Code of Judicial Conduct. I mean, this is just, and guys, this is the footnote. They're literally just copy and pasting all this crap into the statute or into the motion. And sometimes this is how you have to do it. This may seem kind of goofy, but this is how it goes. Steve, are you there?
Yeah, I'm here. I'm just listening.
I'm sorry. Yeah, no, you're fine. I didn't hear anybody, and I'm like, oh God, am I on mute?
Yeah, no, I'm listening. I'm reading a chat. I want to get through this because this is important.
Yeah.
You do have some super chats too.
Yeah. Oh, we'll get to those we'll get to those when we get to the affidavit. We'll take a break. So Rule 2.11 of the Judicial Code of Conduct that says judges shall disqualify themselves where their impartiality might be reasonably questioned. The standard is an objective one, meaning would somebody from the outside. The facts must be considered from the perspective of a reasonable person rather than the interested parties or their advocates, or from the judge's perspective. You know, they say Chief Glanville should not have coerced testimony. And here's the interesting part, and they're just pointing out that even either in or outside the presence of the jury, the judge should never be intimidating a witness. You know, judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned. And Steve, I brought this up because I had a case where we walked into the courtroom and the judge said, "Look, before we start, I have a bit of history in this situation. If either one of you, like the defense or the state, want me to step out, I would understand it." He said, "I don't necessarily think it's a conflict of interest or there's an issue of impartiality, but I'm bringing it to you and you guys can decide."
Yeah, I mean,
And
this is the problem. Why is this
yeah,
judge so attached to the case?
mhm,
You know, there's
yeah,
a certain amount of deference that should be given to your fellow attorneys
yes.
who are saying, we don't feel comfortable with you
Mhm.
continuing. It's like, okay, I got 100 other, there's a many other
Yeah.
cases. Let's switch judges.
Yeah,
Let's
I don't
do
want to do this one anymore. Great. I don't want to be here.
But of course, but there's an investment that this is a
Yes.
prosecutorial mistake by bringing
Mhm,
too big a case, too complex a case. They shouldn't be trying
mhm.
6 people together and having 400 witnesses
Yes.
in a
Yes.
year-long trial. That's absurd.
Yes. 100%. So, the defendants never got notice before, during, or after, and that's the other thing. They were never told about it even afterwards. And that's part of, if ex parte hearings or things have to happen, part of ex parte is that
Well,
there's notice provided that it happened.
and referring back, that's when that first statement, the first paragraph
Yes.
was, there was this big long 2.5-hour break,
Yes.
and all the defense attorneys were
Yep.
waiting. And when the judge came back on the bench, he asked,
Mhm.
what was going on? What's the delay?
Yes.
And it was like, none of your business.
Yeah, none
So
ya.
they were asked specifically. That was the opportunity. The judge says, "Well, we've just been in the back room intimidating a witness," or
Yes.
they could have, if it was on the up and up, it would have been disclosed.
Mhm.
Instead, the guy probably got an email from the defense attorney, as was
Mhm.
proper, saying, "Hey, guess what just happened back there?"
Yes. Yeah. And it's this part, guys, they sat around for 2.5 hours just waiting and waiting and waiting. So where are we at here now? So the defendant should have been afforded an opportunity where a sworn witness was in a critical stage of the trial being coerced. The only logical conclusion is this was to harass and intimidate the witness in the testifying, which, yeah, I agree.
That's what was trying to have. He's trying to
Yeah.
keep it flowing. Let's just get the
Yes.
guy to say what
Yeah.
he's supposed to spit it out,
Yes.
witness.
Yeah, and given all the facts that are assumed to be true, another judge should be assigned this motion to recuse. And it's because they are actually also true.
Now that may be setting up a what is it? A writ of
Rid of a prohibition.
it's not prohibition, it's
Was that
what am I
procedendo? Or writ of removal too, but I don't
no,
know
no,
what
no,
writs
let's
they
see.
have.
Let's see. Writs. I got it's
Writs in Georgia. Well, I remember I had to learn what a writ of procedendo was. I was like, that sounds like that's a cool word. But yeah, there are a lot of writs: habeas corpus, mandamus, chat, prohibition, quo warranto.
quo warranto.
That's the one you're thinking of? Oh, okay.
I think so. Let me just I
Um,
got to look through them. I always, I got to get
is
my
there
writ practice up.
writ of
But it's the one that orders the court to do something that they should do. Quo warranto, without authority. Okay, no, that's
yeah, mandamus would be the writ of mandamus, but you're not.
the worst commanding. No, it would be mandamus then. Yeah.
Would it
So
be a
mandamus,
mandamus?
and these
Okay,
are,
yeah.
and so let's talk about what a writ is. So I think that paragraph
No.
is set. Whoop, no.
Oh, you want
I
to go
think
back to it? Okay.
that sentence is
Yes.
that another judge should be assigned to hear this motion to recuse. So
Yes.
that sets up a mandamus writ. That's an interlocutory appeal, because he is denying the motion for another judge to hear the motion to recuse. And that is something that has to be done. So he has to be commanded by the court above to take this act, to disqualify himself and for the action to occur. So I think a mandamus writ could come out of this. I mean, there's so much. The problem is when it rains, it pours.
Yeah.
And when something's going wrong, like everything applies. That's why you're seeing so
Yeah,
much
there's
law in here.
yeah, which one's the right option? Because one's gonna be better than the others. But and guys, a writ itself is merely the writs go back to common law, back to the King of England. And you would get a writ from the king, and he would give you a writ that basically was a writ to go do whatever. And you were in God mode to go accomplish that task.
Well, it's basically like an executive order.
Yes.
So think about a president would issue an executive order
Mhm.
commanding certain actions to be taken.
Yes.
A judge issues writs to
Mhm.
command under common law to command. In fact, it all comes from English. How much you want to know about this? A lot of
Yeah.
this became
It's the
from
king
English
commanding
common
you.
law and under Sir Edward Coke. And Coke battled the court with writs, if you remember, and between and the king would battle back, and so there was this battle of commands, and so they used writs back and forth. So this is old English common law stuff that is still in existence that is there for a reason, and it's for this very reason right here.
Yes. And those writs going back, there was the writ of mandamus, the writ of procedendo, the writ of quo warranto, the writ of prohibition. There are all kinds of writs. And in fact, under federal law, there's called the All Writs Act.
Right. I love that one. Just whatever it is, it's what the one I'm using, right?
Yeah. There's any number of them. And there's a list of them. There's like, and if you guys Google these, there's a bunch of them that you've never heard, you'll never hear of again, that don't work anymore. But there's, habeas corpus is like the one you guys have heard of before. It's a writ habeas corpus. That one has always been around.
They call that the Great Writ, and that's a command to free. So the executive, the king, in our case, the governor, would have somebody in custody and held. And a writ of habeas corpus is to command why that person is challenging the authority of the sovereign to hold a body of a person and to command their release.
And the other writ you may have ever heard of is a writ of certiorari.
Right.
So getting cert in front of the Supreme Court, you're seeking a writ of certiorari. You're seeking the court commanding you and granting you that ability to come in front of it.
Which is actually the last thing that I filed before I leave the public defender's office is a
just a gog is saying hue and cry. Hue and cry is kind of like a writ. That's an interesting concept back in the day. You know what hue and cry is?
Oh, I don't know. This is a new
concept. Back in the day in England, and this is a common law thing, if the sheriff, and not exactly the sheriff, but if you were commanded to come help, you'd be sitting there plowing your field, tending to whatever. You, Mr. Gosney, we have to kill the highwayman. You are coming with us. We're gonna go kill him and lynch him. You're gonna help us. I got stuff to do. You get arrested. It was a command to come in. You basically got conscripted to satisfy an issue. And you were helping chase down criminals. Basically, it's being press ganged into a posse. And that's the traditional way of doing it. And yes, Nicholas is saying, yes, the writ of attachment's another one, but a bunch of these ones in the middle, like Quorum Nobis, that's that
I've never heard of a lot of these.
I've heard of Quorum Nobis, but it's usually from dealing with sovereign clients. But a bunch of these are, when you get to the Latin ones you guys have never heard of before, they're kind of dead ones. But like supersedis is like the one we just did. Brian Steele covered it. Brian Steele got a writ of supersedis for his bond.
Right. The last act as a public defender that I have made is I'm doing a writ of certiorari before the U.S. Supreme Court. I'm very happy about that because it's a capstone kind of filing.
Well, there you go. Good luck.
Yes.
And they now, and going forward, they say this motion meets all the requirements, and this should be assigned to another judge. In the alternative, should the court deny it, they ask the court to make specific findings of fact and submit that he should recuse himself. So they're asking the judge, they're demanding judge then put it in writing why you're not doing it and make specific findings. And that's just reinforcing the record. Should the court take neither of the above actions, including recusal or making a move to list what's going on, we want a mistrial due to the ongoing bias. And this is a violation of his fair trial rights under due process in the Sixth Amendment. Should all the above be denied, the attorney wants a certificate of immediate review, and the judge denied that. We heard in the hearing. So, and if you guys want to know what the critical stage means, it's one in which a defendant's rights may be lost, defense is waived, privilege is claimed or waived, or in which the outcome of the case is affected in some way. And for a guy to come in there and say, I will lie and take the murder rap for myself, that's a pretty critical stage. That's a pretty critical stage. And this was submitted by Doug Weinstein, and he's submitting an affidavit along with the motion. And you could do that. As an attorney, you could submit an affidavit along with a motion.
Well, and some motions require it, and this is one
Yes.
that requires it. You must
Yes.
file a sworn affidavit in support of your memoranda,
Yes.
because you have to place facts before the court. The motion is just an iteration. So here you have facts that are sworn facts that, if
Yes.
believed, would be true. So
Yes.
a lot of motions require sworn affidavits.
Yes. And guys, this is a docketing order. And this is just saying that you have to provide orders to the court. You have to type them up. That way the court can fill them out, because they don't like doing their own work. And this is if the judge wanted to hear it. He could say, we'll set this he could say, we're pausing the trial. We're setting it for a motion hearing, and we'll do it at such time. Instead, the judge did it in the middle of trial. Okay. And you could argue they ceased the trial to handle the hearing, but they did it in 5 minutes. But it helps the judges saying, I'm not going to grant it. There's a certificate of service saying I gave this to the clerk, the DA's office, to the judge, and I did it. Now we'll get to the affidavit. But before we get to the affidavit, we got to do some super chats and catch up with everybody here. We'll get to this one first. Jim, how are you doing? Jim is saying, does the appeals court sending it directly to the Supreme Court imply they know it's fucked up? Nope. It's because it's a murder case. I will say for the judge, though, that also happens to be bad, because now the highest court in the land, the court that's in charge of discipline, now that you kind of speed ran this, and it's officially in front of them. So
yeah, and I'm not certain.
There might be worse.
There might be a little tea leaf reading, because sometimes if appellate courts will smell a hot potato, and say, we don't want this one. I don't know Georgia law, and so I don't know whether their interpretation is correct or not. Obviously, the Supreme Court thought it was good enough that they took it right in.
Yeah. Yes.
In Florida, it wouldn't work that way, because I don't think this is a death penalty case, right?
Yeah, it's not. It's not.
Yeah, so
in Ohio, it wouldn't work this way either. Yeah. No, it 100% won't work that way. That's a shame. Is a public defender out in Indiana. Is she saying, I'm saying boo to Gosney going to the dark side, but I will try to forgive.
Well, I'm actually going to be training prosecutors. It's the largest prosecutor's office in Florida, with over 500 attorneys.
You're working
they say they hire 80 attorneys a year in the last 2 years. So a lot of this is going to be training them, as well as advising the senior attorneys on all kinds of things, and advising the state attorney herself on all sorts of things. I will not be carrying a docket, although I may come in and dive bomb and pick cases that I can try, help out. I'm going to help out whatever way I can. I will say I only took the job after having long discussions with the entire leadership team with them. Number one, I would not do death penalty cases. And number two, and nor would I assist in those cases. And number two, I kind of led with my ethical precision. I have very strong views about these things, and I was welcomed with open arms by the entire leadership team. So,
and I look forward to what you're going to be able to do there. And I truly think you're going to be doing a massive benefit to the people of that area. So,
and if it wasn't that situation, I wouldn't take the job. I know no matter what they offered me. The fact is that the fact that they want what I am providing, just like what you're hearing here, speaks a lot for that state attorney's office, and I'm very proud to be going there. So
yes. Oh, I like I said, I have nothing but nothing but my respect for that, and my my warmest congratulations. And I know you're gonna make that place better than the way you found it.
And
Not
this,
saying it's
and this
bad
is the
now,
kind of
but
case.
it's gonna be
What
better.
you're watching right here is a good example of what
Yes.
not to do.
Yeah,
Right?
you're going to be able to use this and say, like,
It
"Don't
will.
coerce witnesses in an ex parte hearing."
You
Yes.
see where do Gosney's stories come from? Here you
Yes,
go.
this is it. Yes, the Church of Failure is saying, Monica. Yes, and a Samuel Jackson meme. Yes. John Coleman saying, honest opinion, will there be a mistrial? No. Or does this trial keep going? This is going to keep going until somebody stops it. And by somebody stopping it, it's only going to get stopped if the courts intervene or we get all the way to the end. It's not going to. This is probably going to go
This
for a
judge
while.
is not going to grant a mistrial, no matter
Yes.
what happens.
Oh no, he's not. He's dug in.
Yeah.
He dug in on the hill. Somebody's gonna have to force it to end. Tracy Fagan's been a member for 1 month. They had an ex parte meeting at the bench today. Yes, they did. Again.
See, and that's the kind of thing that would suggest that I think that is grounds for immediate judicial intervention from the appellate court. Yeah.
And you're making the same decision again and again and again. Susan Eckstein is saying, Sean, what's your take on all this? This is in a manifest injustice, the likes of I've never seen. You could put this in a movie script and I would have told you this is stupid. This would never happen. This is laughable. I mean, this is worse than anything you could put in a movie. And sadly, reality is scarier than fiction. But this is how you just, this guy is pissing away any legitimacy that court has. And anybody watching this in America is going to lose faith in the system, and I can't blame them.
Abroad, it's a disaster for the rule of law.
Yes.
Yeah.
And Joe Loy saying Runkle is sound and based. Yes, he is. Sula is saying, did you hear about the judge in Chicago had a lawyer handcuffed to a chair? The lawyer works for my brother's firm. I did not hear about this. Send me an email, potentiallycriminal@gmail.com. It should be down below. I would love to look into that. That sounds hilarious. It also sounds like it sounds really bad, but the idea of somebody being handcuffed to a chair in a courtroom does sound funny. Brian Bryson is saying, watch another pod with lawyer. Okay, I'm not sure which one you did, but okay. Is it possible the witness's life was threatened and that's what caused the meeting with the judge without defense, and that's why the judge is acting crazy? And we talked about this last night, and Brian, thank you for that. That's actually a good question. If there was a threat to this person, the court should have had that meeting and brought the attorneys in and say, one of your clients is threatening this guy. We need to figure out what we're going to do. And if they brought in all the attorneys and they all sat down together, that would be acceptable. But that didn't happen. So,
well, let's take a step back, and I'm going to play a little devil's advocate.
Sure.
Because
tell me, play the devil's advocate.
What if all of this is garbage? What if Copeland is lying up a storm? This is not what happened. Yeah. And what if these are false allegations? Well, first of all, the judge can't rule on the merits of the substance of what the allegations are in the recusal motion. He has to take them as true, even though he knows they're false. Okay, but that's the first thing. But let's assume that the judge knows they're false, and that's why he's acting the way he is, because it's a whole different game here, and the defense lawyers are playing a lion game and using that to recuse and cause a mistrial. Let's assume that's true, right? And we know this guy says he'll lie up a storm anyway, right? Okay, so that's a question. Now, let's assume that maybe this is actually what was going on here, that the defense was wrong. The defense attorneys have the right to be in on that meeting regardless.
Yes.
It's not like young thug defendant's going to come in there and intimidate him in the court.
But the defense attorneys themselves
will. And if that's true, if the defense attorneys were involved on it, now you're talking about bar sanctions against those defense attorneys, and the judge would be all over that, sanctioning these defense attorneys for threatening him, and he's not doing no such thing.
No, and that's the thing. And also, if the defense attorneys were involved, the trial would have stopped, and we would have figured out what we're doing. And those we'd probably have to stop the trial till the attorney sanctions got sorted out. because if the attorneys are involved in witness intimidation, well, you can't have these attorneys committing crimes in the middle of a trial. So everything would have stopped. The trial would have been on pause. But yes, you're right. And if the attorneys were invited into the room, Young Thug and Yak Gotti and all these guys would have to sit in the back of the courtroom while their attorneys are in chambers. That's not prohibited. That's okay because your representative is in the court in chambers. So there's no Sixth Amendment issue. There's no due process issue at that point. Your attorney is there. So they could have done this if that was really a problem. But obviously the fact that it didn't happen that way, and I get it, that theoretically could have been an issue, but there's ways you do that where the defense attorneys are involved. And they would say, Your Honor, it's not my client. I will make sure my client doesn't talk. Whatever we need to do. But this is the way this is going on. It doesn't work that way.
And let's assume that the lawyers, there could be other remedies. Like what about closed circuit TV with the defense attorneys in another room, right? But they're not just doing that; they are concealing it.
Yes,
like Judge and the prosecutor are concealing all the conversations and withholding it from the defense completely.
Like the Darrell Brooks case, the guy up in Wisconsin, they put him in a separate room. While this guy's testifying, you have to sit there on CCTV, and they might stare at the camera and go, "Ooh," but that's not intimidating because the guy's he's safe. He could have done it. There are ways they could have done this, and they didn't do it.
And also, let me also say, the state attorney, if they had information like that, they could move for some kind of protective order.
Yeah.
Or they could do this by motion and allow the defense to speak on it before it occurred. They did it surreptitiously. They contacted the judge without telling the defense. They had the meeting with the judge and this person while he's on the bench without telling the defense, and with no motion, with no notice, with no nothing.
Yeah, and I've actually had case like I've been involved in things where there's a motion that like there's allegations of witness tampering. So they've said, "Hey, one of your clients is doing this," and we're like, "Okay, well, what do you want to do about it?" Like, it's not my idea that he did that, but you're there saying, "Okay, well, there's funny business going on," and the judge's like, "I don't like that." I'm like, and you're like, "Well, look, judge, no shit, I don't like it either." But you have to, you have to say, "Okay, well, what's our plan?" And then you work it out. And that Superwiener is saying, when the prosecutors you work for are a gaggle of retards, like in Georgia, I suppose it's only a matter of time before you two down there can become highly regarded. Yes, I'm sure that I would be considered the most righteous man in Fannie Willis's office. So it wouldn't take much. KRM is saying, can Weinstein's motions and facts attached to the Steele stuff going up to the Supreme Court of Georgia? No, but I'm sure they're going to get wind of it anyway. And they're going to consider what the information Steele raised. They would say, based on the rules of judicial conduct, he should have bailed. Like, they can look at all of that and they'll say, you know what, this isn't contempt. He did the right thing. And then they'll have to deal with the judge later. That's a shame, says, report me, coward, Your Honor. And that's a fair, and these guys, and I commented to the one attorney, Doug Weinstein, on his Twitter. I said, you guys have done this so professionally. I've learned a lot from this, just watching it. Because I would have said something like that. I would have probably said it, though, Your Honor, if you feel the need to sanction me or grieve me, I would say, I would have said, Your Honor, you threatening, if you believe I'm violating the rules, you have an ethical duty to report me immediately, and I encourage you to do so. But I would get out over my skis very quick on that one. These guys did it the right way, saying, Judge, we're just pointing things out. And Sweet Tooth saying, who told the defense? I think it was Copeland's attorney. It's the only thing that makes sense. But I agree with Steve. It could have been one of the bailiffs or somebody who was like, hey, Brian, I got some information for you. But I think it was the attorney. That's the most likely character.
Which is her obligation. I think she might have an ethical obligation to disclose it.
I think she has an ethical duty, but at that point, normally if there's an ethical issue, you'd report. I think you'd report to the judge. But I mean, I think she might be in trouble if she hasn't gone to the state bar and reported it.
Well, they're not going to hold her in any problem with that. But maybe she could. But it's tough. I mean, it's a tough position.
She blew the whistle. I would give her credit.
Obviously, the judge is a tyrant.
Someone
And
blew
I
the
hear
whistle.
also that the attorney that was in there with him was just tagging up for her.
Yeah,
his
well,
regular
if
attorney.
it's like if I called you and said, "Hey, Steve, can you cover this for me?" And you're
Yeah,
like, "Yeah, don't worry. Yeah, I'll show up. No big
sure,
deal.
I'll cover it for you.
I'll Venmo you like $150." And you show up, and you're like, I am not getting paid enough for this. Fuck.
Oh my gosh, could you imagine getting that? So
Yes.
you would never
And
forget.
then you're calling me the next day. You're like, "Now I got to show cause hearing, you asshole."
You threw me into this hornet's
Yeah.
nest. Thanks a
I'm
lot.
like, I didn't know that was going to happen. And I've been like, "Hold on, Steve, you're breaking up. I'm on the boat. Sorry." Mark Lyon is saying, "Hi, Mark. I'm like, I've seen you around before. Thank you for being here. Keep in mind, the court and the prosecutors waited until Copeland's normal counsel was away." And that's what I think was the issue. I'm reading the affidavit. The attorney wasn't available, so a stand-in was there. And then steamrolled the coverage counsel. She likely alerted his normal attorney, who then alerted defense.
It's
That could
interesting
also be.
that I hadn't thought of that,
Yeah.
and that's the next step, which is the
Yeah.
prosecutors initiated the meeting, and they did it when they saw Copeland's attorney wasn't available.
Yeah. And that's actually
fascinating.
fair because, when I've covered for people, I immediately shoot a text to that attorney saying, "Hey, boop, 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 here's what happened." If I get any hearing notices or any documents, I always just take pictures and say, "Look, now you've got it immediately. I'll scan and email them or drop them off to you when I see you." But yes, you always let that attorney know you're covering for, "Hey, here's what you missed." So that's a very good point, Mark. And from the likes of it, the way you're talking, it sounds like you're a fellow attorney yourself.
Well, look at the tie. He looks like an attorney.
Darcy, good to see you as always. And thank you for your support, Darcy. You too, Mark, as well. And in fact, everybody else, thank you for your support as well, guys. I always appreciate it. Nathan Wade did an interview on CNN tonight. Yeah, I heard about that.
Who's Nathan Wade?
He's the guy that Fannie Willis's boyfriend, that she hired to be part of the Trump
Obviously,
prosecution.
Fannie Willis is the source of a lot of this evil here.
Yes.
Yeah.
She's saying, "What the fuck now? He butchered the law and talks about PR. What the heck, Georgia?" Well, I'm sure we'll probably break that down. And while we're here, every Thursday night, guys, if you're new, I do a weekly show where we talk about stuff that's going on, and we'll cover new developments in this Young Thug thing. But we'll also cover what Nathan Wade did talk about. He gave a full interview, said some just scorchers of just awful legal arguments, and we'll pick those apart on tomorrow night at 9:30. So join us there. It should be a fun time.
And that's after my stream at 8:00.
Yes.
Yes.
Where you talk about death penalty designs, maximum due process.
Right. Which, oops, I'm sorry. I've got a sticker on there. Yeah, this is not the actual cover. This is a sample, but death penalty
I got it
design,
right.
maximum due process, which is high-level death penalty law and summary. We're going to talk about what this book is. It'll be released on June 21st, and if you order it, it's an expensive book, but it's only for real hardcore law nerds. I'm going to throw in a prepare second edition in addition to this book, but it will be released on June 21st, and it may only, I don't know, because I haven't gotten the okay to continue my book business, my streaming business, or anything from the state attorney's office. So it may only be available between 21st and the 26th. So get your pre-orders, get your extra prepare, and I will send you Defendants. This is high. If you're an attorney that does criminal law and you want to nerd out on death penalty stuff, that's your book.
Yes. You hear that, chat, though, for you normies out there? He says, "You guys can't understand this."
I'm just saying.
Show him wrong and buy his book and show him you understand.
You can if you think you're capable, if you think you're
man
worthy,
enough?
if you man enough to take on. I actually sent out a promotional email today, said, "Don't buy this book."
Yeah. Are you man enough for the 8-second ride? Can you handle this book? Can you break it?
That's right.
Zero Fucks is saying Steve doesn't know about the writ of Sneed.
I don't know what the risk is. Huh?
That's good. That's so funny. Hairway to Steven saying, "My cats are very aware of your dog. I'm so sorry." When they were barking. Selena saying, "Was that Laney barking?" Yes, that was 100% Laney barking. That's not Clyde's bark. I'll tell you guys when Clyde's barking. View Galaxy saying, "With the mistrial, is a double jeopardy? We don't know." Maybe.
Well, and this is very well. Now,
Yeah.
see, generally a mistrial does not result in
Mhm.
double jeopardy, meaning barred to further prosecution.
Yes.
The exception to that is when the prosecutor
Yes.
initiates the
misconduct.
mistrial. So
Yeah.
prosecutorial misconduct is the basis, and then you
Mhm.
got a shot. And so I
Yes.
think that if there's a mistrial,
I think
we
there's strong
shall see
grounds.
whether or not they can be retried, which is another travesty. It's a
Yes.
loss for
Mhm.
Georgia, because Georgia has an interest in upholding the law and deterring crime. So
Mhm.
you've got dirty prosecutors, you're going to get criminals getting away with stuff.
Yes. And Galaxy, you're right. It becomes an issue, but right now we don't know the answer to that. But yes, this trial is DOA. No matter what happens, if they get convicted, it's going to be overturned. Now, if they get acquitted, no, there's no that's great. The judge will still get disciplined, the prosecutor will get disciplined, but then they get to go run free. So the best situation at this point is probably an acquittal and then or a hung jury, and they just say, screw it, we're not doing it again, and these guys get to go free.
But we're a year away from that.
Yes. Yeah. To 2025.
It's absurd. That's an
Yes.
absurd. It's terrible. It speaks very poorly of this state
Yes.
attorney's office.
Yes. And Nick Croiser saying, I watch lawyers on YouTube. Does that count? Almost. And Nick also gifted 10 memberships.
But
Nick,
but yes, it counts when you give 10 memberships.
yes, it does give 10 members. Yes. That's how it counts, chat. Debbie is saying, do you think the judge has been threatened over this case in some way to make him act so out of character against the laws, regulations, and canons? No, I think he screwed up once. And I think just from there, once you screw up, it's hard to stop, and you're getting attacked. So you double down and dig in and start shielding and fencing yourself in to protect yourself. And after a while, you've basically made a tomb. I'd like to think that, or he just doesn't give a shit. I'm not really sure. I doubt anybody's gotten to him. I don't think that's the case. Allegan News says, who wants to be on a jury for 2 years, $25 a day? Does not cover my cost. I feel bad for this jury. They don't go every day, but I am surprised people have not shown up, because it's a hell of an argument. I'm going to lose my kids are going to be on the street. My kids can't eat because I'm not working. I'm surprised that hasn't happened yet, but it could. And, that's a valid reason not to be on jury duty. Judge, you are killing my family. As Farrell is saying, it's a name maker is why. Very true. John Coleman saying, there's no way the jury has not caught wind of the situation at this point. Well, I think the jury's heard about it as well. Word gets out. And jurors also snoop around on the internet. We know they do. David's saying, you guys should do a weekly history of the law show. Oh, that would be, there's so much there. There's so much
Well,
there.
can I just plug, since it's opportune moment? The first chapter in this is the history of the history of the death penalty, beginning with ancient societies.
Mm-hmm.
So there's a summary of the death penalty going way back, history of the law, and then it kind of moves us all the way up to Furman, which is 1972, and then Gregg, which is the re-implementation, and the modern era, which begins in the mid-70s. So
yeah. And guys, if you weren't aware of that, Furman v. Georgia, is it Georgia v. Furman or Furman v. Georgia? Either way, that
Furman
was
v. Georgia, right?
And that was when the Supreme Court said the death penalty, as applied in America at that point, is unconstitutional. So everything stopped for about 5 years. And then I think it's Gregg v. Georgia came to them and they said, oh, you guys are doing it now. This way is acceptable. And that's where we see nowadays the two-part capital trial, where you have the penalty, where you have the guilt phase and then the penalty phase. So you determine whether or not the guy's guilty first. Okay, if he's guilty, is he guilty of capital murder? Okay, cool. And then we want to step 2 is, do we give him the death penalty or just life in prison? And that's where you have that. You have to have that second step, and that step is a separate. And we've watched it. We talked about it. It's a
Right.
separate
Well, and
trial.
Yeah,
Yeah.
it's I'm gonna talk about a lot about this tomorrow night on my stream.
Okay.
I'm gonna talk about this, about Furman and Gregg.
Mhm.
And yes, it is Gregg v. Georgia. Yeah, and Gregg was the re-implementation, and where they endorsed a system that was set up basically based on the model penal code, in which to implement a death penalty, which had a bunch of checks that were in there. The Furman case is very difficult read. It's very complicated. The only thing the judges agreed on is that the death penalty, as it was currently constituted, was unconstitutional and arbitrary. And
Yeah.
the states scrambled to re-implement their statutes, and Gregg was endorsed. So then all the states kind of followed the Gregg window, and now we have Florida, who is lopping on all kinds of problems that pre-existed. Then that's what the book addresses.
Yes. And then Law Talk with Mike. Mike, it is good to see you, man. I didn't see you in the chat on the side. My apology. Guys, if you guys aren't subscribed, Law Talk with Mike is a very good channel on YouTube. Mike coming to you from Chicago. Very good stuff there. There will be a mistrial. I hope to God there is, but at this rate, it doesn't look like it's going to happen until the court. It's going to be a while before this gets sorted out.
This judge is not going to dismiss, recuse himself, and he's not going to get a mistrial. It's going to have to come.
I think he might get removed. Like the recusal issue, the emergency appeal will get heard, and the higher courts will say, "Yep, new judge." And that judge might do a mistrial. I think that's
what's going to happen. It's going to be a new judge, and the new judge is going to declare a mistrial.
But even with that, I think we're looking at the end of the summer, maybe.
No, I think it might be an emergency.
I hope so. I hope so. John H. has been a member for 2 months. Thank you, John. Is saying, "Hey, Steve, great book, Death Penalty Debates."
Yeah, just so people know,
yes,
we have 3 books, right? So this is Death Penalty Debates. This is the public policy debate. This book is a successor book, which is the legal and constitutional issues. So this is the public policy debate. This is if you're a lawyer and you want to attack the death penalty or learn about how to attack the death penalty. That's what that one is.
Okay. And real quick, Mike is saying, having practiced in front of a Judge Flanagan, which that's an Irish name if I've ever heard one. For years, the chair handcuffing does not surprise me in the least. That's interesting.
Oof.
That's
not lawyers good. Are chair handcuffed?
What's that?
Who's chair handcuffed?
So we remember we had that comment earlier saying an attorney in Chicago got handcuffed to the chair by a judge. Mike is saying that having practiced in front of a judge for years in Chicago, the chair handcuffing does not surprise me in the least. It sounds like Mike knows what we're talking about.
I mean, that's ridiculous.
It is.
I mean, I don't know. I'd report the judge to the grievance committee.
Oh yeah,
I'd lose it. I couldn't handle that. This is a problem. I'd be in contempt. They can't handcuff a lawyer. You know, this is my job.
Especially if it's in front of a jury.
That's ridiculous.
Yeah.
Is that true?
I don't know. Like Mike sounds like the way he's responding to that sounds like he knows what we were talking about. Or he knew more.
I'd like to tell us, Law, if you're still in the chat there, Law,
Mike.
Tell us that. Are you talking about lawyers? And how is it that the bar doesn't get involved in that?
Well, let me see here. Judge handcuffs an attorney. Oh my God, it actually happened.
That's ridiculous.
Holy cow. We're gonna
it's like, why? People cheer on defense attorneys getting abused.
Here we go. Okay. So all right. So we're just gonna read this real quick, chat. I mean, we're talking about judges kind of crap in the bed. Okay, lawyer was handcuffed from the chair after the judge ordered him removed from the courtroom, sparking state inquiry. Okay. Judge Kathy Flanagan was sent to the Judicial Inquiry Board, which means she got referred.
Good.
She's the acting judge of the Law Division, which I hope that the Law Division is ran by a judge. I'm not sure what it's the Law Division of, but you'd want a judge being in charge of the Law Division. A lawyer at a top Chicago firm was handcuffed to a chair after she ordered removed from her courtroom last month, touching off an inquiry. Okay. So the accusations are, the order was issued here. Okay. Where's the, okay.
Can you share the screen? People are asking to share.
Oh, it should, oh shoot. Sorry, chat. There you go, chat. It's on. You guys are getting your screen shared. Mike is here in chat. Where is he? Oh, here you go. It's a civil law division thing. Okay, well, Mike, I think I have you on Twitter. If you'd like to join us real quick for this, because we're talking about judges running amok. Talk. Michael. Oh, he says he can't be messaged. How would we get a hold of you, Mike, to send this to you? If you want to join. If you don't want to, that's fine. I understand it's late. But if you wanted to jump on, I'd send it to you. So it sounds like Mike's saying, did you handcuff her, Mike? He's in Discord. I don't know if I have his Discord. So anyways, we'll keep reading for this real quick. All right. Just post a link in chat. I'm not doing that.
Oh, and this is book number 1, Death Penalty Desired, Passion and Murder.
Yes.
So this is 1, this is 2,
Yes.
and this is 3. So
Yes.
it's a 3-book pattern. And in that order should you read them.
All right.
All right.
Okay. So anyway, let's get to how
We're
this
getting distracted. Focus. Get back on point.
So the incident occurred on May 7th during a hearing at the Daily Center, according to a sheriff's office report. Oh, there's a police report. So the attorney is a guy named Schneiderman. He's making an argument for a client when the judge said, stop talking. And then ordered the attorneys before her to step back. Schneiderman was walking towards the courtroom gallery, speaking in a muttering manner before stopping halfway and turning back towards the bench. The judge yelled, "That's it, take him," according to the deputy, who took Schneiderman to a back hallway and ordered him to sit in a chair, and then handcuffed him to it. Yeah, I don't.
This to me should be that's judicial removal. You know, these judges that think they can abuse attorneys in their courtroom. You wonder why attorneys are unhappy and why good people leave the practice.
And Mike, that's fair. I understand. That's your pond. I understand you might not want to talk about it.
Yeah, but this is you know, all of a sudden these judges, they want to talk about about people like, what do they call it? Congeniality amongst the bar and professionalism
at the bar. Yes, we're all professional.
And then there's people that are pulling this stuff, and then the bar allows them. Obviously, she's still practicing, so the judge is still on the bench.
Mm-hmm.
Is that an endorsement of congeniality?
Yes. And here's the thing, I think that's a bit of an issue here. It's not clear, did she order him to be handcuffed? Or because the deputy says he was handcuffed for security reasons, and he says, that's just protocol. We handcuff somebody we're holding in custody.
Yeah, I don't know.
But I would argue
there's obviously facts here we need to know.
Yeah. When the deputies later presented Flanagan with a remand order to take him into custody, the judge declined and spoke to the lawyer for several minutes before telling the deputies let him go. Now, that's not uncommon where the judge will, like, if you're an attorney and you get a little over your skis, you'll come back in front of the judge, or even
okay, there may be more to this story. Let's not pass judge.
Yeah,
we're just see, this is the problem with the judge like we're seeing in this young thug trial.
Yeah.
We're coming off that, and now we're projecting the worst on this judge.
Mm-hmm.
See, that's why it's so bad for the rule of law, and because now we don't trust anybody. And it brings down a culture of trust is destroyed by this kind of rogue, crazy tyrant in his courtroom.
Mm-hmm. And then
there may be more. We need to not misjudge this. I want to back off. And
I agree. The attorney then returned to the courtroom and brought a court reporter with him. Smart move, getting it on the record. He complained the judge had not allowed him to make arguments on the motion before she granted it. Okay. Instead, the court asked me if I had reached any type of agreement with plaintiff's counsel. I said I hadn't, and that the court then simply granted the plaintiff's motion without talking about the merits of the motion, which that would piss me off too. He said, had he been allowed to explain his client's position, I wasn't given that opportunity. And he said, I have not had an issue with the judge, male or female. Nonetheless, he surprisingly accused me of being sexist, and that's where I think there's more of what we haven't heard yet. You had me taken back in chambers in front of the courtroom without even entertaining the motion on the merits. And then there's more transcript, and the judge, he says, well, this was wrong. And the judge says, are you finished? And then the judge accused him of making statements that aren't accurate in any way. She said, so we're done. But it got referred, so there's a lot to this, and we're gonna have to see what gets out there.
Well, did we finish the Young Thug stuff? Or
Not yet. But
okay.
this was just a side because that was such a big deal.
Yeah,
I
and
thought
we
that-
didn't finish our. Do we have our super
Yeah.
chats? Do we finish the super chats?
Let me see here. We gotta catch up. Not Your Problem says this is why nobody watches Hollywood movies. No movie can surpass reality at this point. True. Elegant News says, I will still say the prosecutor claimed defense was involved in intimidation. How else does the judge agree to this BS? And sure, they could agree to it, but the affidavit is going to show that's clearly not the case. Nick Kreuzer says it was those damned Ricada kids in Eric July who did it. Rick H is saying, I feel like Hilton will be stripped of her bar card. She's probably the most innocent. Nah, you know better. She's not brand new. If this was like her first day on the job, maybe, but she knows better. She's not going to lose her bar card. None of the prosecutors are not going to lose their bar cards.
Oh, I don't know. I mean, they should.
I'd like to see that happen, but yeah, prosecutors. I mean, it's Fannie Willis's office. I just don't expect anything to happen.
All the more reason.
I agree. You need to hang some bodies on the outside of the castle so people know.
Exactly.
Super Wiener says Arita Sneedamus. Yes. Unhung Hero for $2 is not a lawyer, but he stayed at a Holiday Inn last night. And KL Burke is saying, damn, you're making me learn stuff. I know. And Allegadu says jury duty should cover your daily income. That is the cost of freedom. I don't disagree with you. That should be the cost. But, people, nobody does it because very few people do jury duty. That if enough people got inconvenienced, they would fix it, but not enough people are inconvenienced. So sadly, that's how the world works. But let's get back to the actual affidavit here.
So we read through the motion, and this is the supporting affidavit. So this is the sworn testimony.
Yes.
That Weinstein makes in support of his motion to recuse the judge.
Yes. So
these are just the facts. It's not argument, it's just facts.
Yes. And these are under penalty of perjury. Okay. Now, it is a little weird that he starts off with this without saying who he is and what he does. But normally you start off with a affidavit saying, my name's Douglas Weinstein. I'm the attorney in this case. I represent so blah, 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 blah. But he gets right into it. That Kenneth Copeland had been held in civil contempt. And that the judge said that would wait till 8:30 in the morning on Monday where he would be prepared to testify. And that's where they talk about everybody being present in the courthouse at 8:30. And then later, an ex parte meeting was held in the judge's chambers with the judge, the ADAs, and other members of the district attorney's office. So we don't know who. Deputies and the court witness, Kenneth Copeland, and his attorney. Nobody from the defense team was present. Nobody on the defense team was aware. And then 2 hours later, Judge Glanville showed up. Brian Steele said, hey, what's going on? And the judge said his inquiry was not accepted. And by not accepting the inquiry, he says, Your Honor, may I inquire of where you've been? No, you may not.
And that's the Brady violation right there.
There's a Brady. There's a lot of violations.
There's a lot of violations right there about when he was asked what was going on, and he says, none of your damn business. That could be that shows like consciousness concealment.
Yes. So Copeland briefly testified. And upon information and belief, Copeland announced in the morning he would invoke his Fifth Amendment right. Upon information and belief, he said, I would rather sit for 2 years. Upon information and belief, judge informed Copeland that C.J. Glanville could keep Copeland, and that means Chief Judge, could keep him incarcerated until defendants were tried, not just the 6 currently on trial. And that's the threat. I can keep you here for years, which I don't legally think he can anyway. This is when the prosecutors then piped up and said there were over a dozen defendants left to try. Now you guys are saying, well, we already covered this. Yes, we did. But now this guy is saying it, not just an emotion. He's putting his ass on the line. He's willing to say this under the threat of perjury. So there's a presumption he's
Well,
trying
you've
to tell
got,
the
but
truth.
you've got to say upon information and belief.
Belief,
That is the
yes.
wiggle words for saying this
I
is
was
what I've been told. He's repeating
Yes.
hearsay
Yes.
and saying, so this is not evidence, so to speak. He's just repeating. He's saying
Yes.
this is what I understand happened.
But he's saying it with conviction, that he's not just saying, "Oh, well, people talk." He's
Well,
saying
it's
it
very
as,
detailed.
he's saying it as sure as he can be.
Yeah, he's detailed. There's
yeah.
probably an email from the defense attorney with all
Yes.
of this directly.
Oh yeah, exactly, exactly. And that's the thing. This is so detailed. Exactly what's going on. That the coercive actions were there, and that he said, that he would testify. And the judge gave him a printout of the perjury statute, the false statement statute. And that the ADA said, if called to testify, he said I'm going to lie on the stand. And then the prosecutor says, look, if you lie, I won't prosecute you. And that this is when Copeland says, I'm the one who killed him. And then they say, well, if you tell us you're the one who killed him, we will prosecute you for perjury. So this is now when they're saying it for real. Emotion, you can allege all kinds of things in emotion. When you put in an affidavit, you're being very serious about it. So during the courtroom, when one of the allegations were presented to the court, Judge Glanville denied the one or more events above relayed to him were accurate. He's saying no, and this is what the judge denied it all and said, nope, this didn't happen that way. And then it's been signed by the attorney, and it's been notarized, and it's a legit affidavit. Although, if he's an officer of the court, generally you don't have to do an affidavit, but yeah, notarize it. But yep, there you go. That's it, chat. The trains have left the station. The missiles have been launched. There's no going back. And Steve, you were saying,
yeah, if you want to know who this.
Oh, Simone Hilton. Okay, yeah, here we go. So she's not a rum-dum.
She's not a beginning lawyer.
Yeah. Yeah, she's a deputy district attorney, and she heads the did it again. She heads the domestic violence unit. So this is not her first time around the block.
She's the head of the domestic violence.
She is experienced.
And she's responsible for prosecution of cases all the way up through homicides.
Yes. Prior to her position, she served as senior district attorney in the DeKalb County District Attorney's Office. And DeKalb County is right next door. And she was in the DV and sexual assault unit and the crimes against children unit. Okay. She started her career in 2010 in Fulton County.
So she's 14 years she's been an attorney.
Yep, just a little bit longer than me.
Boy, I've been practicing 25 years.
Yeah, you're like, wow, you whippersnappers.
Young punk.
Yeah.
You punk.
You're like, I had to use the Scalextric to type out.
Yes, I did. I had to research with the books, man.
Yeah, those books, those things that never get opened.
The books are great. You know what sucks is the shepherdizing a case with using the books.
Yes.
That sucks.
Yes. She's been around for a long time.
Rising star. No,
yeah. So she's from Philly. Okay. Where did she go? She got her degree from Howard. Okay. She got her JD from North Carolina. Oh, I was going to say North Carolina Chapel Hill, but Central University.
I never even heard of it.
Never heard of it, but again, people haven't heard of Toledo.
Yeah, I love that scene in I love that scene in what is it, Caddyshack, where he's like, "Yes, I'm going to East Howard." He's like, "Where?"
Yeah. Yes.
I'm going to Princeton. I know.
Yes. But guys, yeah, so this is not her first time there. She knows better. She knows better than this. Culpercat's saying, like I said on MG's show, they expect us to believe there's no election rigging in Fulton County. Well,
right. Yeah.
That also leads to reinforcing that issue of, oh my God, this is happening. Yeah.
Yeah, because I'm sure there's a vigorous prosecution of of all,
Mhm.
any kind of election tampering within
Mhm.
Fulton County by the state
Yeah.
attorney's office. I'm sure
Sure.
they're really on top of it.
And Robert Miller saying Copeland's attorney, I think she's meaning at the ex parte sidebar, said she was needing to leave ASAP, but the judge said stop talking, and she couldn't tell him that she was quitting. And the judge denied her. And I did read about this. Allegedly, the judge said you can't leave. And I think he's just saying that because otherwise, if Copeland wants an attorney, he does have the right to have an attorney provided for him there because he is facing issues. So I think the judge is just like, I'm not letting you leave. You're stuck here. So YSL could verify the votes. Yes, this is their second round of prosecutors. They actually had a couple of them. I don't know if they were relieved for being dirty, but the original prosecuting team that was going to do this has left the office. Some have been relieved, I think, but a couple of them have quit on their own because this case is a disaster. You guys saying she's fired. Fannie will not fire her.
No, I think Copeland fired his own attorney.
Oh, yeah, yes, yeah. Yeah,
been there, done that. Son, where have you been?
Happy birthday. Or happy Father's Day, Dad. Yes, guys, Father's Day is it this Sunday?
I don't know.
I think so. Yeah. Happy Father's Day to all the dads out there. And then Enchiladas Unbreaded says, good work, Sean. Well, thank you. I tried.
Yeah, you really, I gotta say, you provide cogent criminal legal analysis. And, I really enjoy being on your streams because I understand you and I relate, because I've been in the trenches and I know where you're coming from. I would say MLS law has been really good. Southern law has had some good analysis. You can tell the practicing attorneys, and you definitely know what you're talking about.
Steve, I coming from you, I truly always appreciate the kind words from you because I respect your experience.
I'm spending a lot of time with you. It's not like I choose cautiously. So Georgia can pay Gazi to help them. I'm not barred in Georgia.
Well, I don't think given their standards of what they're allowing the judges to do, it might not be that tough of a bar.
Yeah, good logic. I do like good logic. Yes. He's not a criminal lawyer, though.
Yeah.
But good logic is also very good.
And Steve, I just mean that because I know your experiences and your knowledge base. I do appreciate it when I appreciate those comments, especially coming from you.
Well, but the thing is that there's you could be on here just like grifting or pushing ideas that entertain or writing things to say what people want to hear, or I don't know, but when I'm listening to you, I'm learning because I'm learning, I'm listening, and I'm sharing, and it's an experience. And that's what I love working with the government. I like working on the prosecutors, the defense team. When you have a team and you get together and you bounce ideas off and you think, and you always learn. Like we had a comment in chat today that the guy said, oh, they waited until his real defense lawyer was off and it was subbing before. That was a very clever comment. And I was like, oh, that's an interesting insight.
That makes sense.
Yeah. Yeah. And so, it expands your mind to bounce these ideas off of you. Yeah.
On a wall, I guess we got people who are digging up stats that North Carolina Central University's law school bar exam pass rate was 56%. Ooh. Compared to other law schools, the average, I guess, for North Carolina is 77%. I can't imagine there are that many schools in North Carolina, though. Okay.
I'm getting quoted. Stabby says, I love working with the government, Steve Goss.
Yeah. David said Phil Holloway. Yes, Phil Holloway is a very good attorney down in Atlanta as well that's practicing. He does stuff here on YouTube. He's actually a very knowledgeable source. Yes, I love working for the government.
People are just trying to stab you.
People are going to clip that from you for you come back to YouTube. I
did civil practice. I did civil litigation for 6 years. I did probate and not criminal law. I didn't do criminal law until I went to state attorney's office. I did nothing. I knew nothing about it. So I was doing civil litigation, probate litigation, real estate litigation, and I didn't have a lot of trial experience. But being with the government, I hate fighting with a client.
Yeah.
And so that was something that was a It's a balance. It's a long discussion. We'll go someplace else.
You did it was like working for a chamber of commerce, weren't you two at some point doing
Well,
work?
before law school, I
that
ran
was
the
before
Volusia
law school,
County
okay.
Home Builders Association. So I ran the HBA. So we run the parade of homes, and all of our members were builders in Volusia County. So a lot of the home builders here who are great. That's why I love my blue collar friends. This is why I'm really, my formative experience was as the executive officer of a home builders association.
Okay.
Because they're very productive. And so then I went to law school after 3.5 years as executive officer. So
Okay.
Yeah.
There we go. Okay. I thought I remembered it part. I was
yeah,
part
it's pretty
correct.
good. Most people don't know those details.
Bass is saying, thank you for streaming instead of driving 80 miles a day for your 5 kids' activities. Well, I try.
I drove my wife to Miami and back this morning.
Jeez.
4.5 hours each way.
Oh.
She has a job interview down there.
Well, hopefully she gets it.
Yeah.
Good luck to her. 10K View says the stream needs chapstick to ensure we don't get chafed lips from kissing each other's asses. Well, hey, got to protect your lips, man. Chapped lips are no joke. I hate chapped lips. Astro's saying that I guess one of the prosecutors in the opening argument said the state said they can't prove their innocence, and he denied a mistrial because of that. He's been very biased. Well, it takes a lot for a judge to want to nuke a case in an opening statement. I mean, I'd love for that to happen, but
how strongly was that rebuked?
Yes.
Did he actually state the law? Was there an objection? And he said, sustained, counsel, the burden of proof remains with the state.
Yes.
You shall not do that. The misstatement of law. Proceed, counselor. Move for mistrial. Well, I'm denying the mistrial.
Yeah.
To correct it. Was that done? Or was it?
If that's what happened, guys, every court in America is going to say, yeah, well, he fixed it. Now, I've had those situations before. I say, Judge, I'd like you to instruct the jury now. And no judge has ever had a problem with saying, ladies and gentlemen of the jury, the burden of proof is with the state. The defendants have the right to remain silent. They have no obligation to present any evidence, any exhibits, or any witnesses. And so it happens at times. John Coleman says, happy sperm donor day. Well, some people, I guess that is an issue. Let's see here. A name of some sources. I love that people like Steve are working for the government.
Is that good or is that
I
bad?
I think he likes that. I think he likes that.
Okay, yeah. Well, I'm really I want to bring people. I understand the roles of the parties, right? And I want to communicate. People are human. All these people are human beings, and we can't discount human frailties, human limitations, human egos. And so what we got to do is bring out the best of everybody and protect the process, because the rule of law is what allows our society to flourish. Without the rule of law, we have nothing.
And Michael Stetson says Phil Holloway's channel is Inside the Law with Phil. It's a great channel. Yes, it is. I've been on with Phil a couple times with Eric Hunley, and he was always great to talk to. Obi says bar scores should be mandatory disclosures. I mean, that's like demanding people provide their LSAT score. Like,
you know what they call the guy that made the lowest bar passing score?
Yeah, lawyer. Yeah. Yeah, I mean, Obi, the way they do bar scores, like for Ohio, when I took it, you had to get 454 points. It didn't matter if you barely crossed the line or you blew past it. That's all that matters is, did you cross the line? Stimpy says.
I just emailed him. I said you have to put that in the form of a super chat in order for me to answer the question.
Okay, we'll answer that question then later. There you go, Stan.
It is clever though.
It is. It's very funny. It's damn funny.
Yeah.
Just Incredible says, what advice can you each give a rising 2L who did okay, not great first year? Steve Gosney, need any intern help next summer? I'm at Stetson, so not that far.
Yes to all questions. Drop me an email. Contact me at stevegosney.com. Go there. There's a contact page. Send me an email. I'll be happy to give you some advice. I can't say for sure, but I know that the Miami State Attorney's Office does have an internship program, and I will be part of that internship program from what I understand. So, and I was a Stetson undergrad. My undergraduate major was history. I have a BA in history from Stetson, and I did my first year at Stetson Law. I transferred to Washington and Lee. My law degree is from Washington and Lee, but so I'm a hatter. I'm a happy hatter. So yes, please do send me some, and I would love to talk to you about it.
And then, could I give you advice? Find a program, whether it's whatever type of program it is, clinic, practicum. Take something where you get a little bit of courtroom experience, because you will be light years ahead of anybody getting out of like law school. You know, I took a job when I got out of school a couple months after I got out and got through the bar, and I worked for a law firm, and we represented oil companies drilling in Southern Ohio. Well, there were a couple times where we had to go, like, guys who were, working on the rigs and roughnecking it. Sometimes they get DUI, sometimes they get drug possession charges, sometimes they get caught with a hooker. Just saying, it happens. Well, somebody would have to go to court and deal with that. Well, the guys who were in my office, like, they didn't, like, a lot of them, like, had experience just, didn't have any experience. A lot of them were new guys. Like, they were just hired on like me right out of law school. But I had taken some, practicums. I had done some clinics where I'd done some criminal work. So I was okay to, like, well, what do I do? It's like, oh, I understand. You go in the courtroom, hi, Your Honor, and you can navigate through it and get it done. That puts you ahead of a lot of people, even experienced attorneys. There are a lot of attorneys who have never set foot in a courtroom, or it's been years since they set foot in a courtroom. So,
and my big advice for jobs, and first of all, if you're in the second year, you did okay. You got through you're in your second year, so you're gonna go, right. So take classes that relate to the bar exam, the Florida bar. Yes. As a Florida lawyer, I'll say take another bar exam that's reciprocity, that you have some reciprocity, because then you can move the hell out of Florida if you don't like it. Go to like an internship. Also, so study for the bar, and let me see what I got. I got lots of advice. Send me, we'll Zoom. I'm telling you, send me an email. I'd love to talk to you about it.
And the other thing I will say, if you didn't do so well, just remember, everybody there was smart enough to get into law school. So assume you're not the smartest guy. Assume that you're behind the curve. And I will say the best way to study is,
Oh, you know what? I'm just thinking. Let me tell you what one of my interns did. Stetson, do you know John Zach? In Ideas and Answers in Law, there's an article on one of the chapters is on BB guns. And one of my interns at the Public Defender's Office, who went to Gettysburg College, he was not a law student, but he was going to law school. John Zach helped me write the BB gun article. So I put him on the case, and we wrote an article together. And he got into law school, went to Stetson. And based on his experience at the Public Defender's Office, he is now joining the Clearwater Public Defender's Office. So,
nice.
That's one of the things I love, mentoring lawyers. And that's what I do at the Public Defender's Office. And that's what I will be doing primarily at the State Attorney's Office. So.
And Justin, you could do potentially criminal@gmail.com. I'll be happy to talk to you if you want to shoot me an email too. But just keep working. Just keep working at it. I had to learn how to go to law school. It was tough the first year. And after that, I kind of got the hang of it. So just take some time.
They scare you to death, they work you to death, and they bore you to death.
Yes. But, in hindsight, like, I enjoyed actually going to law school at the end of the day. I didn't enjoy panicking in between. Like, you take the finals and you wait 2 weeks and all you do is panic that you didn't do well. But other than that, like, actually learning was fun.
Law school, I will say, was the best educational experience of my life. My experience at Washington and Lee Law,
well,
I enjoyed. I made all my closest friends, and it was a phenomenal learning experience. I loved it. So, yeah.
KJ gifted 10 memberships. Thank you, KJ. And Selena gifted 10 memberships as well. Thank you both for your support and your generosity. And I think, are we kind of wrapped up here, guys? We're kind of... Oh, Charlie's saying you should learn Creole when you get down there.
Creole in Miami. I love Miami. I'll tell you, it's a beautiful city. The Miamians, when I get down there, I have to learn to say, "Oh, it sucks. Everything sucks." And the two things is the thing they say is terrible about Miami is number one, the schools, and number two, the food. I mean, the driving, the traffic.
Yeah.
And so I'm going to be I'm going to be living within walking distance of my office. And my son's 20, so we don't have to worry about schools.
Yeah.
So problem solved. And now I get to enjoy the great food. We're right next to Little Havana, which is the great Cuban food, man.
Nice.
Sushi.
Yeah. And Sithandra saying, are we still only reading super chats? No, we're all caught up.
Okay, cool. Fun.
Yeah. Yeah, guys, that is it for tonight. I don't know what's going to happen going forward, but the big issue is Brian Steele's safe for now. As far as what the court's acting any further quickly, nothing was filed today emergency-wise. We're probably kind of run the course for the week. I don't expect any other big... Like, if the judge does something real... Well, possibly, if he does something really, really bad, we could see new involvement. But for right now, I don't expect anything new to happen. I think this week is kind of going to run its course. And then starting next week, I could think there could be some big moves. But for now, I get the feeling we're kind of where we are.
Yeah, I don't see anything obvious because what's happened is the Supreme Court of Georgia has stepped in and prevented any negative consequences. But on the other hand, this judge, I don't expect him to. I expect him to continue his tyrannical rants. And at some point, I mean, there might be some kind of emergency disqualification. I don't know. We'll see. That's a prediction. He will continue to be crazy, and somebody's going to step in. The governor's office or the Supreme Court will step in and do an emergency.
Oh, I agree. He's going to go until someone stops him. And yes, Tater Monkey is saying, is it true Steele was granted a bond? Yes. And his bond was basically, we're stopping it. Steele doesn't have to go post any money. His bond is just like we're just not imposing sentence right now. So it's basically everything is stayed until they sort it out. And that's going to be a little while. But the good thing is this trial is going to drag on for a little while anyway. Saying, sorry, just tuning in. No, that's okay. That's okay.
Yeah, play catch up, and thank you to the replay crews because they don't get enough love. We focus on chats and we love super chats. We love the chatters, but we also like the people who are just watching and the replay crews. So
exactly. Yes. The replay crews are always, love for those guys.
Yes.
And providing food for the algorithm. And Culpercast says, yeah, the judge ain't ever going to stop. Nope. And Durna's right. He's got a shovel under his robe so he can keep digging the hole.
Yeah, I think it's going to happen quicker than we expect.
And if you are in a hole and you keep digging, the one thing to think about is, and I've said this before, and people always look at me like I'm weird, but it's true. If you keep digging, eventually you get all the way to China, and then you're out of the hole. You just have to get there first. A lot of digging.
Well, I don't know. Well, let's see. So what else?
Zero Fucks is saying, are replay scrubs considered chattel too? Yes. That's what I call my chat. They're the chattel. They're my
chattel. That's pretty good. Yeah, what do they call my chat? The G-spot, I think is
G-spot.
It's funny.
Oh. The judge digging this hole could be very helpful for Joe's tunneling crew. Yes.
That's right. Tunneling Jews. I loved it.
Yes. All right, guys. Yes, so we are all caught up for tonight. Steve, is there anything you want to say?
Well, tomorrow night, I'm going to have sort of a preview party for Death Penalty Designs Maximum. This is a preview cover. This is a draft that I've been editing. And but isn't that cool? We can do technology. Yes. This book don't buy this book. This is not for any average fellow. This is only for super law nerds. And it's priced accordingly. But if you do order it, you will get a second edition prepare along with it. And this is, if you're interested, it's a follow-up to Death Penalty Desired and Death Penalty Debates, the third book in the series, and my last book on the death penalty will be Death Penalty Designs. This is a novel, and this is a weighing both sides of the argument, public policy argument, and this is so if you want to understand the high-level legal understanding of what the death penalty is and how to attack it and how to understand it legally and constitutionally, this is for you. Mostly federal law applied to Florida's death penalty statute. So tune in tomorrow night at 8 o'clock on my Rebel channel. We'll party, and there might be rewards for people who buy this book.
On
And,
Rumble, it's Stephen Gosney, right? Your Rumble
it's
channel.
Crime Law at Steve Gosney.
Crime Law Steve.
Crime
Okay.
Law Steve Gosney, and something like that.
Okay.
Just look it up. It's on it.
If you start Googling Steve Gosney, you'll find him.
Steve Gosney.
And-
I'm around. I'm also on YouTube.
Okay. And then, guys, and after Steve is done at 9:30, I got my weekly show. We'll be covering a lot. We've got so much to talk about. We've got, Young Thug's situation, Hunter Biden being found guilty, Sarah Boone getting a new attorney, and then Shohei Ohtani, the pitcher for the Dodgers, his interpreter has pled guilty to gambling and other federal money laundering charges. So be interested to take a look at all of that. And guys, we're all caught up. Kieran Reed tomorrow, guys. I've got stuff in the morning. We might try to start that in the afternoon, but we'll run as late as we can. But then obviously probably end right around 8. Anna Wall says, "This the one on Locals?" No, this one's here on YouTube. This one's here on YouTube, guys. The 9:30 show. Guys, come here to this channel. You guys will see it. It's a fun time. If you're new, I am telling you, you will enjoy yourselves. But that's it for us. So, guys, take care. Just keep your eyes peeled. I think, yes, this judge is going to do more goofy stuff, but I don't think the courts are going to do any more action today. Or this
Not
week.
today, but we only have
not today, but yes.
Yes.
Not Thursday or Friday. It's going to be a boring week in that regard.
I don't know.
Well, I think the judge will do stuff, but I don't think
we'll see. Yeah, it seems like the entire Georgia defense bar is on the attack. So
yes, and it's hilarious to watch.
Yeah.
They smell an opportunity to do their thing, and they're never going to get the chance to do this again. So I don't blame them. It's a once in a lifetime opportunity. So, guys, take care, and remember, till next time, just because you did it does not mean you're guilty. And that includes Brian Steele. He is not guilty of contempt. So good night, chat. Take care, everybody.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law.